Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. My name is Amy Blake and I am joined with Justice Desmond and Justice Hand. We are your panel for today's 6 cases. As we've notified the attorneys prior to the start, each side is permitted 15 minutes. There is no rebuttal. We have read all of your materials, so you should know that and get right to the points. With that, I will call the first case. I will do my best in terms of pronunciation. This is docket number 2020P0562, Trustee of the Mary D. Iatridis Revocable Trust versus Christos Zahopoulos et al. With that, Mr. Iatridis, I'm sorry if I'm mispronouncing your name. You may proceed and you will see the clock where the court seal is. Thank you.
Thank you, Your Honor. And the pronunciation was pretty good. It's Iatridis, so I appreciate that. Good morning, Justices, Counsel. My name is Iatridis, and I am the trustee in this case, the plaintiff below and the appellant here. I'm also an attorney representing myself, and as you can see, I am one and the same person, a key issue in this case. The main issue for the court to resolve is whether the trustee, me, is the party litigant here. If yes.
Before you get into that, sir, could I ask you, because in your papers, I believe you suggest that our review is de novo, and opposing counsel with citation to authority says it's for an abuse of discretion. So could you clear that up for us? What do you believe the standard of review is?
The standard of review is de novo because we're interpreting a statute and applying the law to facts.
And do you have a case for that proposition? What case do you have that says that we review this de novo?
I don't have that cited in my brief, and I don't have one off the top of my head. It's pretty standard appellate review law that I've seen in many jurisdictions, including this one in prior cases, Your Honor. But the main standard of review is deference, which is what the SJC established in the Borman case.
Well, does deference in and of itself suggest discretion?
No, deference, in fact, in Borman, the SJC expressly said we could adopt a discretionary standard or a deference standard, and they rejected the deference standard explicitly. I'm sorry, they rejected the discretionary standard when the attorney is the party litigant, and that's different from the cases cited by defendants here. They're not addressing the line of cases where attorneys are the party litigants. And in Borman, they rejected the discretionary standard, and it's right there in the briefs. And if you look at Borman and relied upon by the subsequent progeny, they do not apply a discretionary standard. It says we defer to the attorney who's a party in the case how to manage serving as a witness and as an advocate.
Mr. Iatridis, you're bringing this matter as the trustee, not as a beneficiary, correct?
Correct. Did I address your question sufficiently, Your Honors, about the standard of review?
Well, typically we rely on law, and so if you could have pointed us to a case, I infer that Borman is your best case. Is that what you're telling us?
Well, it's Borman, it's Gorovitz, and it's Lux. That whole line of cases did not apply a discretionary standard. And Borman, the SJC, which is precedent for this court, rejected discretion. I mean, in black and white, just clear. It's not even it's been decided long ago. If I were not a party litigant, that is a different story. And that's how the defendants are arguing this case.
Well, you clearly represent the trust, right?
I represent the trustee myself. The trust is not a legal entity. It cannot be sued. It cannot sue. It is not a legal personality, as in the case in Larson on page 18 of the opening brief makes it clear. All title to trust assets are in the trustee's name. All contracts are in the trustee's names. All lawsuits are brought in the trustee's name. If the party were the trust or the client, then that case would get booted out because it's not pled correctly. The trustee is the party in interest here. Now, as a trustee, I have fiduciary obligations, which is what the Larson case says. And here's the quote, Your Honor, Justice Desmond. Quote, he being the trustee, he is acting for himself, but with fiduciary obligations to others. So the court has resolved that issue as well. I am acting for myself, and as an attorney, I am representing myself.
Did you seek attorney fees in this matter?
Did I? Well, I have put it as one of the requests for relief, yes.
And so what do you say in response to the Verizon case that your your adversaries cite for the proposition that neither a civilian nor an attorney, when acting pro se, is entitled to an award of attorney fees?
First of all, the claim for relief as attorney's fees is dependent upon statutory claims that award attorney's fees. Second of all, as trustee, and as a trustee who has hired myself to be an attorney, the trust is obligated to pay the attorney. So there's different ways of seeking fees, but the fees sought in the case below is not because it's pro se, it's because the statute allows it. But that has nothing to do with the issue before this case. It's the Verizon, and that issue is a distraction. It doesn't matter who pays or not in this case. The case is about whether I can represent myself, and am I the party litigant?
Are the estate matters still pending in the probate and family court?
Yes, there are several.
And this action was not filed there?
Correct. This action was filed in Superior Court because of the request for a jury trial, which is not allowed in probate court.
Do I recall that you gave a different explanation for why you filed in probate court at another time in this case from the record? Perhaps the proficiency of the Superior Court with this subject matter?
There is that as well, that the types of claims at issue here, because there's a blend of issues, but these kinds of fraudulent transfer and the nature of what happens in probate court is a completely different experience than in a Superior Court, which tends on average, of course, to give more attention. We have breach of contract, fraudulent conveyances, legal malpractice, quiet title, etc. So these are, in the judgment of the strategy, and I can't reveal work product, of course, but a strategic decision was made about where to bring these claims. And, that's part of the litigation process, and having deference to what attorneys decide where to bring cases.
Changing tacks a little bit, could I ask a different question? Understanding this and assuming for a moment that you as the trustee have the right to represent yourself pro se in this matter, does the judge's obligation to ensure the appropriate fairness of the trial process and the litigation process necessarily have to bow to that statute?
Okay. Well, in Looks, if I'm pronouncing that case correctly, which followed Gorovitz, which followed Borman, the court said, the appellate court there said, that the trial court, in order to disqualify counsel, must make a finding that the circumstances there taint the legal system or the trial of the cause before it. And that legal finding was not made by the trial court here.
Does it have to be made in those words?
Well, either yes or the equivalent. The only thing the judge cited was confusion. That's not taint of the type we're talking about. If it's confusion, then jury instructions or structuring the trial, or even at worst, it would be eliminating a jury trial because a judge can handle those issues. Confusion is a standard that is completely different than taint, but the judge didn't use those any word to be tantamount to taint.
So just taking one portion of that explanation, do I understand that you're saying that even though there was a request for a jury trial, if the judge decided that the appropriate way to handle the confusion was to eliminate the jury trial that you had requested, that would be appropriate?
Since it didn't happen, I haven't researched it, but to me, considering my point that I made in the brief is that there are far less drastic measures that could be taken than the one chosen by the trial judge. And saying it'll be a bench trial allows the rights to be vindicated if they have merit, of course. And whereas here, it just stops it dead in its tracks. It cannot go forward. So that is the point that was being made. Research-wise, I'd have to look at it, but confusion is not taint.
But I take it that no suggestion along those particular lines was made to the judge at the time that the motion to disqualify was being argued.
About a taint, that is my understanding, correct. It was just a straight application of the rule 3.7 as if the statute did not exist.
And as far as less onerous or less drastic, I think is if I'm misremembering the word that you used, I apologize, but less drastic means that particular option wasn't offered to or suggested to the judge either. Is that correct?
I believe I cited a case in the brief that said there are less drastic measures to complete disqualification, and those could be explored. And the case cited gave examples. So it was raised below in my opposition brief, towards the end of the brief.
Thank you.
But just taking that one step further, if you haven't researched whether or not it would have been permissible for the judge to disregard your request for a jury trial and suggest that there will be a bench trial, then how can that be a viable option?
Well, the request, the taint that is of concern that I've read in the case law that drives the rules of professional conduct is mostly driven concerns about juries. And bench trials, of course, can properly address issues that cannot be addressed by juries. And if the issue is taint, the judge can much better manage that. The reason I say I haven't addressed it is that it was obviously a possibility, but the court never even raised it. The court just took it. The court did not consider, did not discuss what guardrails could we put that are less drastic. The court just went to the drastic measure and, stops the case in its tracks because it cannot go to trial.
Well, let me ask this though, that the issue is you weren't at the trial stage when this decision was made, correct? This was
Yeah,
early in
this
the
was
case.
way early. It was on motions to dismiss, no discovery, nothing.
Right, and so the judge's ruling was limited to restricting your representation to trial and depositions for the reasons that the judge provided in the memo, correct?
Yes.
So that there wasn't any prohibition on moving forward with the case under your direction, and in fact, with you representing the case, but for those exceptions, correct?
In effect, it does, because there's no money to hire a lawyer.
But no lawyer would be required to be hired, if I'm understanding correctly, other than potentially for depositions and for trial, but not as to the other issues that you raised. For example, examination of documents that might be in Greek, a language which I understand you're proficient in, or educating another person in the general background to do more broad discovery, understanding that depositions are one among the many discovery tools available to you. Those things weren't restricted by the judge, correct?
That is correct, but that's only applicable if Rule 3.7 is what governs. But when there's a statutory right, those are not considerations for the judge, because we have the rule of deference, and it's a right to be witness and advocate. I see the time has expired. Can I finish the answer?
No, let me just see if Judge Desmond or Judge Hand has any further questions.
I do not, thank you.
No, I don't.
Okay, we're going to have to leave it at that. Thank you.
Thank you.
Attorney Finkel, I believe you were going first. Is that right?
Yes, Your Honor.
For 12 minutes. Okay, you may proceed.
Good
Counsel,
morning,
would you
Your
be,
Honors.
good morning. Would you be kind enough to begin with the standard of review, please?
Sure, Your Honor. The standard of review is abuse of discretion, and it is well-established law in Massachusetts for orders of disqualification that the standard of review is abuse of discretion. I draw your attention to the Smolin Beach Association versus Genova case from the Supreme Judicial Court, 461 Mass 214, 220. It's cited in page 11 of my brief, and specifically Smolin Beach states, as this analysis hinges in large measure on a judge's balancing of the respective prejudices to the parties, we review disqualification orders for an abuse of discretion. Similarly, that standard is set forth in the Steinert versus Steinert case, which is appeals court case that ironically was cited within the appellant's brief, yet he chose to cite the Borman case, which quite frankly is silent as to the standard of review and certainly does not state the proposition that the appellant is saying that it states. It is very clear that it's an abuse of discretion standard, and as Your Honor pointed out to the appellant, the idea of providing deference and giving deference to the trial court in the decisions that are made, that is the very definition of an abuse of discretion. That is the standard. We're supposed to give deference to the trial court in those types of situations, and it makes sense that the standard of review is abuse of discretion because of the analysis that the court has to do in order to determine whether disqualification is appropriate, particularly under prong 3 of Rule 3.7 that requires the court to consider whether there's any sort of adverse impact or I want to get the exact words here, so I apologize. A substantial hardship. The court has to balance, when we're talking about hardship, it's not just a hardship to the client for the lawyer that's being disqualified, but it's also the balancing has to be done with the court and also considerations of the other parties. And in a case such as this, certainly my client, Alice Taylor, is a lawyer. She's not a member of the family. She's been brought into this matter just because she was retained by the decedent to do some estate planning work for him. And she gets a right to a trial. She gets only one trial. And the fact that, as Judge Henry pointed out in his decision, in laying out all of the issues with Attorney Iatridis being involved not only as a lawyer, but also as a trustee, as the central figure in this matter in order to prosecute the case, that there's really no other alternative but to have him disqualified for trial and for depositions. As Justice Hand pointed out, it's limited to trials and depositions. So there's nothing that's preventing Attorney Iatridis from litigating this matter with the extent of those prohibitions. Now, one point that I do need to make, that the trial court does not have the authority to simply take away a jury trial. Jury trial, we have Rule 38.
Well, you could strike a jury trial request for example, a discovery violation or some obstreperous behavior during litigation as a sanction, though, right?
Sure, as a sanction, but in a situation like this would be a situation where the relief requested would be in order to avoid the imposition of Rule 3.7 of the Rules of Professional Conduct. Certainly, Civil Procedure Rule 38 and Article 15 of the Massachusetts Declaration of Rights clearly provides the right to a jury trial. So I think in a situation like this, where we're raising this, and we're raising this now, and we did it at the stage, at the pre-answer stage, because of the nature of this case, the fact that there are 10 defendants in this case, the fact that the complaint was 85 pages with close to 1,000 paragraphs. In order to avoid a true hardship, we did this now as opposed to on the eve of trial, and that would certainly put the appellant in a bind that certainly is not here. And the only hardship that was raised down at the trial court level was the fact that allegedly the appellant could not find a lawyer to take this matter on a contingency basis, as opposed to hiring counsel on an hourly basis. And there are alternatives, there's statutory alternatives that would entitle the appellant to recoup any monies that were paid on behalf of the trust. So the fact that this case would somehow be stopped dead in its tracks, I certainly disagree. And again, as Judge Hand pointed out, this particular order applies specifically to trial and to depositions. The other point that really needs to be made here is the fact that the Attorney Iatridis is not a pro se litigant in this case. And Rule 17A of the Massachusetts Rules of Civil Procedure is very clear in a situation where a trustee is allowed to bring a case on behalf of a trust in his or her own name, the real party in interest in such a situation. And Rule 17A is not just limited to trusts and trustee, it's beneficiary contracts and whatnot, but the real party in interest is the entity that the rights are being asserted. And I think really what drives the point home in terms of whether or not Attorney Iatridis as a trustee could be a pro se litigant, I just draw your attention to the quote from Judge Cornetta in the D'Souza versus One West Bank matter, which is cited at page 18 in my brief, and then is included in the addendum beginning at page 55. And Judge Cornetta states, an individual cannot litigate claims held by a trustee, and a trustee cannot litigate claims held by an individual. And simply put, Attorney Iatridis is not representing himself in this matter. He's representing the trust as a trustee. He's not prosecuting his own individual claims. He's prosecuting claims that belong to the trust. And he does not have General Laws, Chapter 221, Section 48 is not applicable in this situation because Attorney Iatridis is not the real party to this action.
Mr. Fink, I have two questions. I'm just watching the clock, so I want to try to get them in. At page 22 of your brief, you indicate that the plaintiff did not make any equal protection claim below. And while I've looked at that, the papers below, although not perhaps stated that way, do you think there's a colorable constitutional argument that he's raised, or no?
No, Your Honor. First, that argument was never presented before Judge Henry. But not only that, if it's an equal protection, who's the class or what's the class that we're trying to protect? I mean, he's making the argument that if we were to disqualify Attorney Iatridis because he's a lawyer, it would be unconstitutional because a non-attorney would still be allowed to represent the trustee. The law, and we have the Kitris matter in the appeals court, and actually there was a case that was not even cited in my brief that was from last year, the Braxton versus City of Boston case, 96 Mass Appeals Court 714 from 2019. It was an appeals court case, very clearly states that a trust is a legal entity with separate rights and responsibilities, and that a non-attorney trustee who is not a beneficiary may not represent a trust in legal proceedings.
And my second question is, you say that you're entitled to fees in this appeal. Those wouldn't be necessarily statutory fees, but because you say the appeal is frivolous, is that right?
Yes.
And could you describe for us why you think you're entitled to fees?
So in the fees are warranted in this matter because, first of all, Attorney Iatridis has presented incorrect law in cited cases that actually has the correct standard of law, yet cites the incorrect standard, was put on notice of that, didn't correct his brief or attempt to correct his brief. The arguments that he's making are not novel, and they're tantamount to frivolous arguments. The law is very clear that a trustee has to be represented by counsel, that in terms of, as Judge Cornetta pointed out, that an individual can't litigate claims by a trustee and a trustee can't litigate claims held by an individual. But not only that, but the brief itself was just colored and full of superfluous materials and was clouded by pot shots that were taken at the court. And certainly I would suggest, and it's unfortunately this has been what it's like down at the trial court level, and certainly I think in this is a situation where sanctions would be warranted in terms of.
And there was no reply brief filed in this case, right?
Correct.
I see that your time is getting close. Justice Desmond, Justice Hand, do you have anything further?
No.
Attorney Fink,
did Attorney Iatridis, excuse me if I'm butchering your name, I apologize. Did he suggest to the court below that he'd like to withdraw his request for a jury trial and move forward with a bench trial?
Your Honor, I don't recall him making that that suggestion. I would point out, because we never got to file an answer because we wound up prevailing on the motion to dismiss, we would certainly ask for a jury trial in this matter anyway. And if that case ever comes up, or if the situation ever comes up, we would be seeking a jury trial. But I do not ever recall that being a suggested alternative.
Thank you.
thank you very much. Attorney Hirsch, when you're ready.
Thank you. Good morning, and may it please the court. My name is Jillian Hirsch, and I represent Christos Zahopoulos in his individual capacity and as personal representative of the estate of his late wife, Anna Iatridis. Counsel for Ms. Taylor has addressed the bulk of the issues before this court on the appeal. I would
But
like to.
he's the brother-in-law. Is that, I just want to get the family, he's the brother-in-law.
That's right, Your Honor. Anna was Maki Iatridis' sister, and Christos is
Okay, thank you.
her husband. So I will just address one point briefly this morning. Attorney Iatridis contends that he will suffer substantial financial hardship if he is disqualified, and therefore the exception to Rule 3.7 applies. He complains that there is no money in the trust to pay for an attorney, and he should not have to bear the expense by paying for one out of his own pocket. But that is exactly what he should be doing, to the extent an attorney must be hired for purposes of deposition and at trial. Attorney Iatridis himself points out that Section 709 of Chapter 203E of the Massachusetts General Laws provides that a trustee shall be reimbursed for monies he advances on behalf of the trust. And it is not uncommon for trustees to find themselves in precisely the same position that Attorney Iatridis finds himself in now. He contends that he shopped around for an attorney who would take this case on a contingency basis, but that no such attorneys exist, that no attorney would take this kind of a case on a contingency basis. It's simply not true that attorneys don't handle cases such as these on a contingency basis. As Attorney Iatridis himself explained this morning, the case that he filed is replete with the types of claims that attorneys regularly take on contingency fee bases. But Attorney Iatridis' claims of financial hardship are particularly disingenuous, when contrasted with the significant financial harm that he has caused my clients in connection with this lawsuit. My clients have incurred in excess of $100,000 already to date in legal expenses as a result of this litigation that Attorney Iatridis has commenced. They had no choice in the matter. They are not attorneys, and they needed to hire an attorney to defend themselves. They had to take out a second mortgage on their home and dip into their retirement savings, even as my client Anna was battling an aggressive form of cancer that ultimately took her life. And my clients, unlike Attorney Iatridis, cannot avail themselves of Section 709 of
We're
Chapter.
going to have to leave it there, Attorney Hirsch, unless either of my colleagues have any questions.
No.
Okay. We have your briefs. I know there are additional arguments that each of you wanted to make. We have read your materials. Argument has been very helpful, and we thank you all.
We are live and on the record.
Thank you. The next case this morning is the Department of Mental Health versus AR, docket number 2020P0002. Good morning. My name is Amy Blake, and I am joined by Justice Desmond and Justice Hand. We are your panel for today's proceedings. I think unless there are any questions, you both know that each side is permitted 15 minutes of argument. There is no rebuttal. We have read all of your materials, so you should feel free to jump right in. I would ask that you remain on video when the other person is presenting, but please mute yourself when it is not your turn to speak. So with that, I believe, Ms. Nearing, you are the appellant, so you may proceed. The clock will appear where the court seal is right now once you introduce yourself.
May it please the court, my name is Ilse Nearing and I represent AR. Procedurally, there is no difference between a petition to appoint a successor guardian under 5-311C and a petition to appoint a guardian to a person who has never had a guardian before under 5-306B. And the source for that is the Uniform Probate Code section 5-311C, which says, quote, before appointing a successor guardian, the court shall follow the same procedures to safeguard the rights of the incapacitated person that apply to the petition for the appointment of a guardian, end of quote. So the procedural—
Which means that we still have to have in the lower court a competency determination or a capacity determination.
It means that the procedural protections and the sufficiency of the evidence requirements are identical. So yes, all of the determinations that must be made under 3-306 must be again repeated under 311C.
So could I ask you about the medical certificate to start with? If you look at the Mass Uniform Probate Code 190B, section 5306, it talks about the court may appoint a guardian if, and there's a laundry list of things, but one of them is that there's a required medical certificate to be dated within a particular period of time. And 5303 also indicates that the petition must, and at section 11, include the medical certificate. And so I've spent some time thinking about your hearsay argument as it relates to the medical certificate. Do you have any published case that says one way or the other that the medical certificate comes in notwithstanding the hearsay that might be in it, or is absolutely precluded, other than sort of the general rules of evidence? In other words, is there anything specific to the medical certificate in our case law yet?
I believe that this is a case of first impression when the hearsay argument in the lower court has been preserved.
I was guessing that you were going to say that. So I want to ask you, and in fairness, you may not have thought about this, but by analogy, if you think about statutes that, for example, allow a guardian ad litem to be appointed in the probate court, there's a statute that says that what the guardian ad litem is supposed to do. And then there's a case, it's called Gilmore, that says that the report comes in provided that there's an opportunity for cross-examination. So by analogy, and I know they're not the same, but in thinking about this case, what I'm trying to figure out is if the code requires the medical certificate to be filed, like the statute requires a guardian ad litem report to be filed, and not only was the doctor subject to cross-examination or available, she was subjected to cross-examination, why doesn't that protect your client's due process rights?
Well, because first of all, in this case, there is no such statute which permits the admission of this certificate into evidence. Second of all, I believe it's the Hood case that I cited in the reply brief. So all attachments to a pleading are incorporated into the pleading, and also in the comment to the Uniform Probate Code, it says that these certificates and affidavits are to give the judge a perspective outside of what the lawyers are telling him or her inside a court. And I think that if we look to the words of the Uniform Probate Code, we see that the person is entitled to a hearing, is entitled to a lawyer, is entitled to cross-examine. The burden of proof in contested cases is a preponderance of the evidence. And also the purpose of this code is to avoid the overkill which had existed before, and the presumptions that once determined incapacitated, you were forever incapacitated. These are not paper cases. They are to be tried.
Did the Department of Mental Health introduce the medical certificate?
This is another example of the procedural irregularities which riddled this case. DMH did not move it in on their direct. And
did they use it? Did they use it on their direct at all? Did they reference it?
No, they didn't reference it. But if Judge Monk's, just the Judge sua sponte moved it into evidence. And if this was like the opinion report, which Justice Blake referred to under some kind of a statutory exception, Commonwealth versus Marquardt, would permit the attorney to use the inadmissible report on direct to impeach or to cross-examine, and only the sentences which the attorney elicits are the ones that would be moving into evidence, not the entire 4 corners of the document from page 1 to its very end.
Can I ask you on the front page, so this is at impounded appendix, so it's record 2, page 5. It's the front page of the MedCert. And there is a block under instructions for completion, and it says exactly what the document will be used for, whether or not to appoint a guardian. And it is signed not just on the first page, but on the last page under the pains and penalties of perjury. So in thinking about your argument and the cases that say that in civil proceedings, pleadings are not evidence, does an affidavit stand on a different footing because it is in fact a statement signed under the pains and penalties of perjury, as opposed to any other number of pleadings that get filed in a civil case?
Absolutely not. Hearsay is hearsay unless it is admissible pursuant to case law, statute.
Well,
or
my
rule.
question's a little bit different, and trial counsel did a nice job below identifying which portions of the MedCert and the clinician's affidavit that she was objecting to. Because I appreciate the hearsay argument. I hear you loud and clear on that. Please understand, I'm not at all dismissing that argument. I guess what I'm trying to figure out is if an affidavit in a civil proceeding stands on different footing. We use affidavits in civil cases all the time. Restraining orders, harassment prevention orders. We use them in verified complaints that are signed under the pains and penalties of perjury. Why isn't the affidavit different than any other pleading that's filed in a civil case?
Because pleadings are not evidence. A verified pleading is not evidence. It simply states what the proponent will bring in evidence, observing all the rules to move evidence in during a contested trial. And in the Uniform Probate Code does not allow for signed affidavits by psychiatrists to come in. If that was indeed the case, there would be no need for trial. These could just be paper cases decided by the judge alone in his or her chambers.
I just wanted to thank you for your reply brief and the distinction between the MedCert and the MedCert affidavit. I really did appreciate, unlike in other cases where folks do correct things. So I do appreciate that, Attorney Nearing, as I'm sure my colleagues do. But to further Justice Desmond's questions, I appreciate that when the judge said, shouldn't we move this into evidence? Your trial counsel colleague was in a tough spot. If we were to look at the MedCert and strike from it the things that your colleague was specifically objecting to, and those are set out nicely in the transcript, is there still insufficient evidence to issue a guardianship?
Yes.
Why?
Well, we have two separate. The evidence was legally insufficient to determine that AR lacked legal capacity to make medical treatment decisions to justify the imposition of the limited guardianship. The psychiatrist's opinion on that AR was incompetent was legally insufficient, and all the facts that would have, when we take out all the facts, all of that were objected to, the skeleton of what was left was legally insufficient to support a conclusion that AR was legally incapacitated, because an incapacitated person is an individual who is not only has a clinically diagnosed condition, but is unable to receive and evaluate information or make or communicate decisions to such an extent that the individual lacks the capacity and ability to meet the essential requirements for physical health, safety, and self-care. And once all of that hearsay was stripped and when we're just left with the boilerplate of the form, the elements are not met. And then when we look at what Dr. Goodman's admissible testimony was, her testimony also didn't fill out the necessary elements as described under the code and supplemented by case law such as Lane v. Candora.
This was a one-witness trial, right?
Yes, Your Honor.
And the only witness was indeed the doctor.
Yes, Your Honor.
And so if you remove all of the hearsay, you say their case is reduced to what?
The case is reduced to Dr. Goodman's admissible opinion that AR was incompetent, was legally insufficient, because the gravamen and foundation of her opinion was her estimation that AR was making unwise decisions which would not achieve optimal outcomes. But her opinion is legally insufficient because it's not the definition for legal capacity under the code. Not only is the code what I read to this court to receive and evaluate information or make or communicate decisions to such an extent that the individual lacks the ability to meet the essential requirements for physical health, safety, and self-care. We have to look at a case like Lane v. Candora, which illustrates the legal capacity to receive and evaluate information or make and communicate decisions merely requires an understanding and appreciation for the choices presented and an understanding and appreciation of the consequences of his choice. And
So-
Lane
I'm sorry, go ahead.
Lane says that the law is protecting this person's right to make a decision. Judge, the psychiatrist is saying he's making unwise decisions. It's unwise to choose Prolixin over Invega Sustenna because Invega Sustenna is the optimal decision for the optimal psychiatric treatment outcome. But the law protects his right to make that decision for Prolixin, and he was meeting the essential requirements for physical health, safety, and self-care. According to the record, he was living in a group home. He may not have been living the optimal life that Dr. Goodman thought he could have if he took Invega, but he was meeting the essential requirements.
The doctor's view on the Invega wasn't just speculation. He had indeed performed better when he was on Invega, is that right?
Yes, but if we look at the case as Lane v. Candora, Mrs. Candora was presented her choices. And one of the choices, amputate your leg and you can live. Don't amputate your leg and you're going to die sooner of gangrene. She had the capacity to understand and appreciate her decision. She chose against the amputation and she was going to have a shorter life. And the law protected her right to make that decision.
And here AR complained that the medication made him dizzy. Is that fair to say?
That's what he said. And for Dr. Goodman, she's saying, well, he doesn't understand the benefits psychiatrically outweigh the risks of dizziness. But that wasn't her choice to make. That was AR's choice.
As an expert, and she was qualified as an expert, and I don't believe that was over objection. I think there was some questions to make sure that precisely what she was being qualified to do. And if we use, and I'm looking at a criminal case right now called Grenadier that talks about direct testimony of an expert. Hearsay cannot come in on direct, but it can come in on cross to help understand the basis of the opinion. And I feel like that's what happened here. And I appreciate again that trial counsel objected, but wasn't that the proper place for this? Any deficiency was overcome by the cross-examination here.
No, because only the sentences and phrases which AR's counsel brought in would come into evidence, not all four corners of the document. So, it's in one of the footnotes in the reply brief. She only brings in very few in state cross-examination that he hadn't engaged in any harmful behavior. He hadn't indicated he was going to leave the home. And he's going to stay in this home. And who did she speak to when filling out the medical certificate. None of those filled out the elements to define an incapacitated person. And Marquardt makes clear, if you cross-examine the expert on their opinion report, only those facts which you bring in on your cross come into evidence, not the entire opinion report.
Could I ask you about your 16L letter, which had to do with judicial notice?
Yes.
What could Judge Monks have taken judicial notice of?
She could have taken judicial notice that there were prior dockets, that there were prior orders, but she
But
wasn't.
not of the med-cert.
No, because it makes very clear that the med-cert is part of the pleadings. Pleadings are not evidence under statute in this Commonwealth. That's General Law, Chapter 231, Section 87. And that objection was preserved. And even when we look at 303, these probate court forms are part of the pleadings. And that is DMH's burden, to use the rules of evidence and trial to bring in what they are going to
But
prove.
they're part of the pleadings pursuant to the code, which is a statute.
And the code makes no exception for this hearsay to come in. It doesn't say pleadings are evidence. These pleadings which supplement the petition and are thus incorporated into the petition are evidence.
Okay. I want to make sure, Judge Desmond and Judge Hand, do you have any additional questions?
I don't have any additional questions. Excellent brief, by the way.
Thank you, Your Honor.
All right, Attorney Lightfoot.
Good morning, Your Honors. May it please the court. My name is Veronica Lightfoot, and I'm representing the department. The hearsay argument with regard to the medical certificate was waived. It was waived, and it wasn't until
Get there. I had trouble following that in your brief. How is it waived?
the hearsay argument is waived because it is not posed before that court, before the probate court, that the total medical certificate is hearsay. And let me just direct you to the information that is included in this brief, in the testimony, to which there is no objection.
Well, but there is. The judge says, shouldn't you move this in? And counsel was a little equivocal, understandably, and then says, subject to my motion in limine. And she sets out very specifically in her motion in limine what her objections are.
In her motion, and then she comes back, Your Honor, and in that motion in limine, she argues that these are pleadings. These are pleadings versus exhibits. She does not argue that the total medical certificate should not be admitted. She
Okay,
then
but
goes,
let me ask you, record one, I'm just going to pick one, 87 or 88. The entire section is multi-level hearsay, unattributed hearsay, speculation with no personal knowledge. It's not based on firsthand knowledge. There's prejudicial characterizations. I mean, maybe she didn't use the magic words, but for all intents and purposes, this was an objection to not only hearsay, but to totem pole hearsay.
Your Honor, this was not an objection that would lead this court to make a determination as to whether the entire medical certificate should be admitted or the entire clinician's affidavit should be admitted beyond the hearsay exception. That is not preserved before this court. I will address, however, that prior to the point in the record that Your Honor has taken us, there is sufficient information to support the preponderance of evidence burden that the department had to meet that was not objected to. There is sufficient information on direct exam as to this expert's opinion, to which there is no objection.
So the same question I asked your sister, if you excise from the medical certificate all the places where there's an objection or purported objection, including what's set forth in the transcript and the motion in limine, you say there's still enough meat on the skeleton to meet your burden.
I say that and I can direct the court to each specific point to which there's no objection. If the court would look at the record appendix at page 70, you have the doctor who testifies that she has seen the patient once every 2 to 3 months. You then have her testify without objection that she spoke to the director of the group home on October 12th. That's on page 71. She speaks to schizophrenia, a specific diagnosis of mental illness, without objection on page 72.
Well, you do have objection on page 71. After saying that she spoke with the director of the group home and looked at his medical records, based on your conversations, observations, review of the medical records and patient history, do you have an opinion? Objection, it calls for hearsay, overruled. So there's the objection.
That objection, Your Honor, goes to whether or not he was urinating in the trash can, walking backwards. And if you remove those statements from that group home, you still have sufficient evidence that the doctor observed him unkept, with a body odor, lying in bed. She even filed the medical admission for him to go to the hospital in May of 2018. But to finish with this, Your Honor, and why I believe that this is waived, in the transcript, during the initial part of this hearing, attorney for AR actually directs the court to look at prior medical certificates and to look at prior clinician affidavits that have been filed in this case. Again, as with trying to admit this on cross-examination, she can't have it both ways. It can't.
Can you tell me where in the record you're referring? I just want to make sure we're on the same thought process of that.
And of course, I had it tabbed.
Sorry.
No. I should have tabbed it better.
What's improper about pointing to prior pleadings?
Nothing. And there's nothing improper about noting that here, this was admitted into evidence on cross-examination. It's all in evidence, Your Honor.
All right, I'm sorry, I didn't mean to distract you from looking.
No. It's in the record on page 67, record appendix, the first volume. It's when the attorney seeks to have the court distinguish the living conditions. She directs the court to look at prior medical certificates and previous clinician affidavits. And I also want to state to the court that in practicing, I cannot dispute that there's an exchange between the judge and an exchange between the attorney with regard to admission. But the attorney had an obligation to say, Your Honor, I do not want to admit this medical certificate. I want to stand on my motion in limine. And even if it got admitted, she could have renewed that objection, but she also did not have to then take and use that medical certificate and repeatedly refer to it during that testimony. I also would note that there's no redirect here in terms of attempting to use that medical certificate. The only party to use the medical certificate was AR's attorney.
If AR's attorney was using the medical certificate in a way that did not call for its admission and pointed to her motion in limine and assumed that the motion in limine was seeking to exclude the medical certificate in its entirety, she wouldn't have to choose between those two. She could object to the introduction of the medical certificate in whole and continue to use it without introducing it in a permissible manner under the rules of evidence, correct?
That's correct. She could make that strategic decision as in Mark Vart, and it stated that that's what can be done on cross-examination. She could.
And didn't she propose that on page 86 maybe of the transcript? I can ask about a document without having that document entered into evidence, and motions in limine are either to strike the entire document or in the alternative to strike specific portions thereof. And then it appears to me that she refers to certain sections of the medical certificate that she'd like to have excluded. So doesn't that seem to suggest that there are other portions that she wasn't moving to exclude?
It suggested, but as it plays out in actuality, she then addressed them. But I still want to say, Your Honor, that there is sufficient evidence in this record that was not objected to prior to this point in the record that shows by a preponderance of the evidence. And I also want to state that here, although we're dealing with a guardianship case here, we are dealing with a limited guardianship and limited, and as Your Honors know, to the scope here. But there is nothing in the record, as the parents put in their petition, that showed that that AR was no longer capable of functioning for himself. There was not a process followed, no evidence and no medical certificate that showed that he was no longer unable to take care of his medical needs. So in other words, we have a limited guardianship, and now we have the need for a successor guardian. And the process that was being followed is that the limited guardianship had to be properly terminated. It was not. And I'm sorry, Judge.
No, the limited guardianship was essentially for his ADLs, and the guardian had the medical, right?
Yes, that's correct.
And he could also choose to live in the group home.
Yes, that's correct, Your Honor.
Okay. Do you agree with your sister that the code, these are my words, not hers, is silent as to the admissibility at a trial or an evidentiary hearing of the med-cert and the clinician's affidavit?
I directed, Your Honors, in my brief to an unpublished opinion, and I did hear Your Honor ask for a published opinion, which is why I did not refer to it sooner. But I believe that the statute, I'm certain that the legislature intended for the medical certificate to be attached as a threshold document. And I want to address Justice Blake, when you brought up about the use of an affidavit, to me, and I thought before this argument, this is akin to an affidavit being attached to, let's say, a preliminary injunction. And once that's submitted, it's a pleading. But when one may be attempting at some point to cross-examine someone to get to the truth of the matter, or to address maybe something that could be perjury otherwise, then you can use that on cross-examination. And that's how we have this medical certificate being used and entered into evidence in this scenario.
Is the unpublished opinion was NC, right?
That's correct.
And in NC, the judge made an interesting statement that he or she was admitting it as it's a standard court document and the doctor is subject to cross-examination, but in NC, the doctor was not there and was not called.
That's correct.
Okay, so the fact that the doctor was there, that makes this case different. I recognize NC is an unpublished opinion, but that's the distinguishing factor, right?
I think it's a distinguishment in terms of the facts, but I think this still goes to the fact that in this case, the document was not entered on direct. It wasn't entered on direct. And that's the similarity. And the reason I did not put this at the front of my brief or argue it to you initially is because it's not a strong similarity. This isn't on all fours, but I am saying that it matters that it was not introduced indirect. And when I look at NC, it also indicates that this court has at least passed upon the premise that a medical certificate has been entered into evidence. And that's what I'm presenting that for. You all, this court has passed upon the fact that a medical certificate has been entered into evidence.
Do you have anything to say about your sister's 16L letter concerning judicial notice?
I have something to say about both of the 16L letters because I do not believe that they are pertinent or significant to the matters here. And so I do not believe that they were used in the proper manner. They somewhat circumvent the page limit requirement that this court has. They don't present any new legal standard, and it did not give me a fair chance to reply when something is sent on December 29th. For an argument on January 8th, but I did look at those cases and I can address those in turn.
Did Judge Monks ever say that she was taking judicial notice of the MedCert or the affidavit?
I
didn't see it, but
didn't see it. I've reviewed this transcript extensively and I did not see judicial notice having been taken. But with regard to that case, Your Honor, that in the first letter,
yes,
these cases were combined, they were consolidated. So we're not speaking of findings that are similar to the cases that were presented in the 16L letter. Both of these cases, the petition by the parents and the petition by DMH were consolidated. So the findings that are referred to are they're relevant, but I would agree that the determinative factor are those things that will be found in that direct testimony and that are in the properly admitted medical certificate. As for the second, I see a lot of time.
Time has expired. Let me just check with my colleagues to see if they have anything else.
I would just ask you to just touch on briefly the substituted judgment argument. I mean, here AR would speak with folks kind of when he wanted to speak with them. If I needed a ride, or he kind of picked and chose his spots when he felt that he would discuss certain things. And then on other occasions, he would not. And in this case, he said that he preferred a particular medication, but didn't like another medication because it made him dizzy. And certainly not an uncommon circumstance in these cases at all. So what's the strongest argument you have that it was appropriate to have a substituted judgment?
Your Honor, the strongest argument that I have here is that AR was hospitalized twice during the appointment of these temporary guardians on September 2017 and in May of 2018. And that's when he was taking that medication orally. The injections would give him more of a consistent regimen. And as the doctor testified to, and you'll see in the transcript, she stated that that would then hopefully help him from being rehospitalized. That's my strongest argument on that, Your Honor.
Thank you.
Counsel, thank you both very much. Very well briefed, very well argued, very, very interesting case, and we really have benefited from your arguments this morning. Thank you both. The matter is under advisement.
Thank you.
Thank you. Excellent.
We are live and on the record.
Thank you. Good morning. We are calling our next case, which is NATHALIE Majorek versus David Hayes and others, docket 2020P0390. Good morning. My name is Amy Blake. I am pleased to be sitting today with Justice Desmond and Justice Hand. We are your panel for this morning. Each side is permitted 15 minutes of argument. There is no rebuttal. I understand that the appellees will be dividing their time equally. So Attorney Nestor, when you are ready, you may begin.
Thank you, Your Honor. Good morning. And on behalf of NATHALIE Majorek, I appreciate this opportunity to argue to you. Essentially, what my client's position is that the Superior Court judge erred in two reasons. One is we submit there were material facts that were in dispute that should have been allowed to proceed to a trial, namely on where the boundary lines were of this way in question. And then number two, the question is whether in fact the land in question was public or private at the time that Mr. Hayes authorized the tree service to cut down the trees. It's our position I would rely on essentially the affidavit of Edward Manion, who was attached to my memorandum, who was an expert who essentially said that the land had reverted to private under the act of discontinuance, and therefore under the derelict fee, my client owned in fee simple halfway to the rest of the middle of the way.
Was your portion, let me ask you this, sir. Did the portion of the way that we're talking about, was that indeed discontinued? What's your position with respect to that, for starters?
It's our position that it appears from what I can see on the deeds and the plans that it in fact was discontinued. And the reason for that is I would also note, which I noted in my pleadings, is 641 has a rear entrance, and the plans that show the rear entrance, which also shows on the act of discontinuance, is considered a private way. Now this was emanated, as I listed in my brief, by a 1920 plan of Linehan to the prior owners, clearly delineated as a private way. I've listed three different deeds that listed that property as having a private way. It is not a scrivener's error, as my brothers would represent to the court. And in fact, that private way came back in 1920 after allegedly the County of Essex took the property in 1888. So I would submit that there is an issue that it was in fact discontinued. If it's discontinued, it's not a public way. And just for the record, as far as the use, the city of Beverly has essentially never used that portion of which is purported by the defendant to be a public way since it was reverted back to the city. The city has the area.
Does that matter? Does that matter whether they used it or not?
Well, in addition to them showing intent that they don't treat it as a public way, the defendant, Mr. Hayes, doesn't treat it as a public way because he is laid out in my client's affidavit. He has blocked the access and is treated as a private driveway for himself during the entire time that he's owned it since 2015. So despite the representations of Attorney Femino, his client has treated this thing as a private way, his driveway, since he's owned it in 2015. So in a sense, he's de facto acknowledging that it's a private way, only for the purpose of these arguments has he now raised that it's a public way, and because it's a public way that my client doesn't have standing. It's interesting to note that neither Mr. Hayes nor Iron Tree Services has ever represented to any court what they believe their authority was, if in fact it is a public way and those trees were in fact on a public way, what their authority was for cutting down those trees.
So let's assume for the sake of discussion that it was a public way. Then how does your client prevail? Because she has to show that he knowingly cut down the trees of another. So what difference does it make whether he has some authority to show it's a public way? Let's assume it is a public way. The burden's on her, right?
Well, I understand, but if it's a public way, then essentially I would submit the burden kind of shifts, because if it's a public way and the defendant is now claiming it's a public way, but he's admitting that he cut down the trees, then
there's no dispute he cut down the trees.
That's
Is that
correct.
fair to say? Okay.
He cut down the trees in a public way. And I would submit to the court, if he cut down the trees in a public way, which he knew was a public way, he had the requisite intent. And I would point out that the Judge Fay down below alleged that my client in one respect didn't have standing to pursue it, but then the flip side said she had standing as a citizen of the city of Beverly to pursue it. So I'm not quite sure. And on one leg, she's got standing. On another leg, she doesn't have standing for the same trees and from the same area in question. And
so that trespass count survived the motion of summary judgment. It survived. Eventually got dismissed somewhere down the road. do you agree that the surveys certainly depict that the trees were not on her property?
Well, that's why I raised it. I raised an issue in my brief because there are two surveys, which I pointed out, one of which is the original discontinuance one in 1945, and the other one is the 2018 existing conditions.
Are there two or three surveys?
Pardon me?
Are there two or three surveys?
Well, there's two surveys I'm talking about. The 2018, not the 2016, but the 2018 plan of Dana Perkins, which is exhibit number 24, and the discontinuance plan, which is exhibit 6. Those are the only two plans that list a hedgerow. And if you look at the photographs that was attached to my appendix, there are a number of photographs which shows this hedgerow on Hale Street and going to this way. And it was pled in the lower court, but was never addressed by the court. If you treat those hedgerows, which the other plans don't, and you do a line of sight, that potentially moves that boundary line of the quote difference between the public and private way. And I would submit that so we have that dispute because we've got 3 plans that don't have the hedgerow and say it's public land. We have 2 that say there's the hedgerow, so it might not be. We don't have the dimensions from the 1888 plan when this thing was first established. It was never recorded. All we're relying on is the 1945 Act of Discontinuance and the plan there, which they are representing. This is what the way was, but there's no reference to go back and fact say was this in fact the entire way. And that's coupled with the fact if you look at the way it's laid out there, and a number of the plans show it, there's only a portion of which is gravel. The rest is grass. I have no idea how long it's grass. My client has already disputed, and it's in her affidavit, it's in her deposition, that the fence, which everybody seems to make a big deal about, was not, she did not consider that her boundary. She had put an electronic fence for animals on the other side to the east of that fence into the west of the gravel portion, and she treated that as part of her way. So her property line went to there. So if we presume that her property line, in fact, it could have gone there, but for this dispute, then we become with the issue of whether, in fact, she has, as a private way, a right pathway through, and then we deal with the issue: what was Mr. Hayes' authority, even if it was a private way? I know Attorney Femino lists out in his argument. He cites a number of cases that say if it's a private way, he still has the right to make certain repairs to it. The cases he cites, when they talk about items that are not related here, oftentimes you can clear a way, a private way, when you concede it, if you have to clear it because it's obstructing, you can't drive through or anything like that. Clearly by the pictures that are shown, Mr. Hayes could drive a dump truck down that way. He did not need to remove those trees to drive his dump truck through. He didn't.
What picture do you rely on? I'll be honest with you, it's not super clear to me. So it seems like, is part of the way wider than other parts of the way?
It appears, well, it appears if you look at the gravel seems to be the same width as you go down the gravel. The up front where the grass is, it seems to be slightly different. I don't think there's a measurement in any of the plans that show.
Which record, though, are you at, Mr. Nixon? There are a bunch of photos. I think they start at record 166. And I agree with Justice Desmond. I'm not clear. There's 2 that have blue X's. What are those? 166 and 168.
They show my client's property. That's the split in the driveway where the driveway goes off to the right to my client. It's 166.
Okay, and 168?
That's the same thing. That's her side drive off Hale Street where it's split.
And 170 is the stumps.
170, that whole series of the stumps.
All right, so where's the gravel picture?
I pull them out and then put them back in. So
I'm sorry, I just.
No, that's fine, Your Honor.
I want to go back to 172 after you do this.
If you look at 191, you'll see where it's gravel. the top right photo, you'll see where the trees are cutting, you'll see gravel to the left.
My 191 is a quick claim deed. That's why.
Mine as well.
91.
What is it?
91. If you look at 93, you see the entrance coming off Hale Street. And again, that's gravel. And that's facing Hale Street. So you're inside the property. And to the left is the hedge.
Oh.
Hold on, let me get there.
I got you.
So 91, that's
I'm not
exhibit
sure I
8.
do.
91's exhibit 8. All right, what are we looking at in the top right?
Look at the top right of 91. You're going to see the fence. You're going to see the cut trees. And to the left, you're going to see the gravel driveway, which goes around. That goes around behind Mr. Hayes' house. And in fact, goes to the back of 641.
So
And
the
then
fence,
what's 93? Is that the driveway?
93 is the entrance to driveway from Hill Street.
Okay.
whose driveway?
The driveway, the way in question.
Okay. So 191.
I'm sorry, 91.
91, I apologize. That fence is fencing in your client's property. Her property is to the right of the fence?
Her property is to the right of the fence.
Okay.
And my client's position is that fence is not on the boundary line.
Okay.
And if you look at.
She suggests that the boundary line goes how much further to the left?
To include the trees. To include this stump.
So all the way to the gravel.
That's correct.
All the way to the gravel.
If you look at Exhibit 24, which is the 2018 plan, the location of the tree stumps are not that far outside the fence.
Mm-hmm. Exhibit 24, you say?
The 2018 plan, it's page 309. That shows the hedgerow. And it also shows where the location of the trees are. And some of those trees are just outside that fence closest to the way. And it's off the gravel, it's on the grass. And that's, for the record, it's clearly delineated. The gravel portion of the way is clearly delineated. And if you look back at page 91, that gravel showing going behind Mr. Hayes' house and exiting and bumping against the back of 641. And Mr. Hayes' land court deed clearly shows that way going to the back behind his house.
Mm-hmm.
Understand, Mr. Hayes' boundaries are clearly delineated by the land court plan, none of which go across that driveway or way, or public way, whatever you want to call it.
But he doesn't claim that it's his land.
Well, to a point he claims it's, he's got two arguments. One, he claims if it's a public way, it's a public way. If it's a private way, which is the second half of Attorney Fenlon's argument, then I have the right, because it's a private way, to go and cut what's in that way. He's claiming both those trees are in the public way or the private way. He's got both arguments. And he says in the one argument, it's a public way, I guess I can cut them. And the second argument, he says it's a private way and I'm entitled by law to cut them if they somehow obstruct me. An argument would be, one, it's a private way, and two, he doesn't have the right to cut trees down that do not obstruct his ability or his access. And I submit there's been no showing that somehow he needed to cut those trees, and timing is everything. I'd also point out these things were done 15 days after he purchased the property.
Was there an assertion that was the only way that he could reach his driveway?
No, because he's got another entrance. He's got another entrance to the far left-hand side of his property in Hale Street, which is now he's got it fenced off, but there's always been a separate entrance to his property.
Is that depicted in any of the exhibits?
Off the top of my head, I'm not sure whether it's in any of the pictures.
Well, what's the photo at record 85, there's a big truck with something attached to it in the back. And there's a chain link fence.
That's
Right.
his truck, that's his equipment. He's in the construction business.
So that's not the other entrance that you just described to Justice Desmond?
It may be, but I'm not sure. If you look at page,
Is that his house?
that's his house,
Okay.
which I understand has now been demolished. He's building a new house, but that's,
But I apologize, I interrupted you. You were gonna say if I look at page what?
I believe it's 87.
Yeah,
You'll see the two paths, which is the city's property. And I believe to the far part, there's an entrance that comes off that same driveway to his second entrance.
Are we looking at the smaller picture on the, which picture are we looking at in 87?
If you look at 87 on the left-hand picture, which shows the traffic on Hale Street,
Yeah,
then you see a concrete pad.
yeah.
That's the part of the city property where the pumping station is, and the far side of that pumping station, there is an entrance to Mr. Hayes' property. And I'm trying to see if I can find a better picture of it.
I think I understand the gist.
Could I ask just one quick question that's a detailed
Please.
question? Attorney Nestor,
Yes, ma'am.
do you say that your client's deed gives her any right, specifically the deed gives her any right in the way?
Any rights to property?
No, any right in the way? Does the deed include any, I'm thinking about the derelict fee statute language. I'm just trying to clear up that one loose.
There's a description of the property, which if you look, it's I think it's lot D and C, that it shows along the Linehan's map, and so the issue becomes where that property line is, which would give her the right to it. There's nothing specifically that says she has the right to use that way, but it's referenced. It's referenced in the plan, which shows those two lots abut the way.
Okay, thank you.
And I
any
guess
other
I'm not-
questions, Justice Desmond or Justice Hand?
Thank you.
No, thank you.
Okay, thank you, Mr. Nestor. I believe we're gonna now hear from Attorney Costa.
Yes, Your Honor.
Okay, when you're ready.
Thank you, and good morning, members of the panel. May it please the court. My name is Adam Costa. I represent Iron Tree Service, a co-defendant in these proceedings. As was referenced earlier, I intend to split my time with brother counsel, Attorney Femino, who represents the co-defendants, David and Dory Hayes. If the court will indulge me, what I would like to do in my brief time is address two, I guess, of the three topics that have been presented. One is the location of these trees that were removed, and the second is the status of the way as public as opposed to private. Attorney Femino will then address the issue of what if this way is deemed to be private. How does that change, if it does change, the situation? So on the first of these two topics, Your Honors, the location of the trees as it relates to the way and the plaintiff's adjacent property. Now, the trial court relied upon two things. One was a succession of plans that you've already heard referenced so far this morning, a 1945 discontinuance plan, and then a series of not one, not two, but three separate survey plans, and also a tree sketch prepared not by the defendants, but by the plaintiff's expert herself. And then secondly, the trial court relied upon the plaintiff's own testimony, own deposition testimony, and a concession that was made during that testimony. So I'd like to first address the plans because I think that they speak for themselves. One of them, as I said, you've heard referenced already, that is the 1945 discontinuance plan. It's at page 199 of the record appendix. And contrary to what Attorney Nestor suggests and the plaintiff argues, that plan is quite clear, and it's accompanied by a discontinuance decree. And it's quite clear about which portion of this quote unquote way was discontinued. There's no suggestion anywhere in the discontinuance decree that the entire way is discontinued. In fact, to the contrary, there's a very specific description in that discontinuance decree as to the portion of the way that is discontinued. And if you look at the accompanying plan at page 199 of the record appendix, the description goes hand in hand with what's shown on that plan. There's an angular measurement that is described in words in the discontinuance degree, 60 degrees, 33 minutes, 20 seconds. That's shown on the discontinuance plan, the angle between the main road, Hale Street, laid out by the Highway Commission in 1905, and the line that was going to demarcate the remainder of the way that would continue to exist after the discontinuance.
So let me interrupt you right there. So I'm looking at that portion of the plan, and it looks like if we follow along that 60, 33, 20, it almost creates a little slice of pizza in that corner there, right? We're looking at the same thing. All right. And so you say it was discontinued inside the slice, outside the slice?
I say outside the slice, Your Honor, and in fact, it's marked right on the plan. If you look just to the left of that on your plan, in capital letters, it says portion discontinued. Now, what's important, Your Honors, is that if you look at the succession of plans that were submitted, and again, there were 4 total additional plans. 3 of these were the plaintiff's own plans: an appraisal sketch that was prepared in connection with the tree appraisal in 2016. That's at page 301 of the record appendix. A survey plan prepared by Perkins, also in 2016. That's at page 202 of the record appendix. Both of those plans, the sketch and the survey, are entirely consistent with what's shown here. In fact, Attorney Nestor referenced a hedgerow and suggested that there's some inconsistency. I beg to differ. You can see the hedgerow on the discontinuance plan. It's marked as a hedge. It goes just along the portion discontinued, but is within the remaining way, within the way that remained after discontinuance. If you look on page 202 of the record appendix, this is the plaintiff's own survey plan. That hedgerow is shown. It's shown within the way. It's not shown within Ms. Majorek's property. It's shown within the remaining way. Similarly, while I'm on the topic of the plaintiff's own survey plan, there was a suggestion that inconsistencies exist because the wooden stockade fence doesn't demarcate the boundary. You looked at those photographs, a series of them in the appendix, including page 91 of the record appendix, that show that wooden stockade fence and show the way running alongside it, show the location where the trees were removed. The argument you heard is, well, that fence doesn't demarcate the boundary. Well, again, the plaintiff's own surveyor disagrees with that. If you look at page 202 of the record appendix, the wooden stockade fence is shown there. It's shown within the boundaries of the plaintiff's property. Not only does it demarcate the boundary, it's actually anywhere from a couple of inches to maybe as many as a couple of feet onto the plaintiff's property. So these plans speak for themselves. The judge relied upon these plans heavily. The judge also looked to something in the record appendix, specifically page 246 of the record appendix.
Can I interrupt you for 1 second while we're talking about 202?
Yes,
so I see the wood stock fence. So, okay, I see. All right, never mind. I answered my own question. Sorry.
That's okay. So, Your Honor, Your Honors, on page 246 of the record appendix is deposition testimony. I had the opportunity to take Ms. Majorek's deposition prior to filing for summary judgment. There's an exchange. It's also reprinted on pages 13 and 14 of my brief, where I asked Ms. Majorek where these trees were located. I said, are they located on your property? And she initially said to me, well, yes, they are. And I said, are you sure? On your property or on the right of way? And she said, well, you know, and I'm paraphrasing, but well,
he hedges a bit.
That's a question of terminology, she said. And I said, well, I'm going to push you on the issue. Which is it? And she finally concedes they're within the right of way. So for it to be argued now, or frankly, even on summary judgment previously, that these trees are on Ms. Majorek's property, it's contrary to her own plans. It's contrary to her own concession during deposition testimony. And with that, I'd like to move on because I've got just over a minute left. And I'd like to address this issue of the status of the roadway as public. I've cited to a case in my brief. It's the Mahan versus Rockport case. It's on page 11 of my brief, 287 Mass 34. It's an older case, as many of these tree cases are. But this case is important because it sets forth the standard. It is settled that a public way, once it's duly laid out, continues to be such until it's legally discontinued. And in fact, in the Mahan case, the land court judge below had found that the town of Rockport had taken an easement for a public roadway 40 years prior. It had never even entered, according to the record evidence, never even entered onto that portion of property. certainly never constructed the roadway. And still, the land court found, in the Supreme Judicial Court affirmed that until a discontinuance decree was issued, until the statutory process was followed, that roadway still existed. That way still existed as a public way. The only thing that complicates this case at all is the fact that it was created as a county way. As your honors probably know, most county governments, I think all county governments, were abolished in Massachusetts over a period of about 15 years. And in 1998, the Essex County government was abolished. But there's special legislation. There's a statute, Chapter 34, Section 60, that says that the county way becomes a city way. It's now owned by the city of Beverly. With that, my time is up. And so unless there are further questions of me, I will yield the floor to Attorney Femino. Thank you.
I don't see any. So Attorney Femino, when you're ready, the clock will begin. And you feel free to sit whatever makes you more comfortable.
I've been standing for 39 years. I'll stand back. Good morning, Justices. My name is Len Femino. I represent Dory and David Hayes. I'm on the private side of the road case. That's how Adam Costa and I divvied up the work on summary judgment. And the reason the private way segment is important to this argument is because the appellant wants to claim that she owns to the middle of the way if it's private. Therefore, it's her property. She has the fee underneath the way. Therefore, that gives her some special status for these trees that were cut down. So my focus has been private way. That's not the law. The law is, yes, she owns to the middle of the way, but everyone who has a right to use that way, and every abutter, and mainly David and Dory Hayes, have a right to maintain that way for its full width and full length. There's nothing about, well, if it's only gravel in the old days, it gets to stay gravel. He can improve that private way, full width, full length. And that's
Best case for that.
The cases are in my brief. So everything that not only that, the case is cited by the appellant, namely the Silva case, the Gillette case, and the Gilliam case, all say, and in every case that I cited in my brief, it's black letter law that full width, full length, and why? Think what Massachusetts would be like if the roads 100 years ago had to negotiate through private property rights because someone who abuts doesn't want their wall removed or their trees removed. This is a designated land for travel, and it's essential for David and Dory Hayes. When this old house was built 120 years ago, the fire engine down the street had little horses on it, and it was a small little thing. But now it's a hook and ladder. It's a big truck, and that big truck needs to get to that house. And the only access is the way we're talking about here. No confusion. There isn't.
Now, let me just interrupt you for a moment. Are we talking about the big truck, fire truck, or the big truck we saw depicted in the picture?
Well, everything, every truck, every car. Mr. Hayes and Mrs. Hayes have the right to improve this way to its absolute limits. In these cases cited by even the appellant, if you read them carefully, what they're telling you is, the focus is, are you making the way more passable? Are you making the way a better traveled way? And if you're doing that, he is fine for the work that's doing. So in the cases I cited, land court cases, this issue comes up more than it reaches the appeals court. And when you read those cases, stone walls get removed. There's a case in my brief where Marilyn Sullivan, a land court judge back when I was in the 1980s, was so heartbroken to remove the stone wall, but she made it happen and said, well, you can build a wall on your own property next to the road. So
how did the removal of the trees improve the way?
It made it, these trees are in the way. They're in the way. Some of them are in the way up to about 5 feet. So by taking them out, It makes the road wider. It makes it easier for access. It makes it clearer. Another way of looking at this is the appellant has the right to allow those trees to grow, but subject to my client's right to remove them. So it's a conditional right. Or thought differently, if the appellant here is not arguing, I can't get to my street. My access has been diminished. My travel way is somehow damaged. No, she's saying I have privacy rights. I have shade rights. The air is being blocked. I liked my privacy. Well, if she likes that so much, she can plant trees on her side of the fence and on her property. But this right of way is subject to improvements. There's a case that's cited in my brief, and it's a Boston case, it's the Killian case actually, where there's a court in Boston, a road, where the elevation of the street was so changed that the plaintiff in that case, to get to his house, would need a stepladder. When they were done doing the work, his access to his house was damaged. He had to go down 3 steps. That's how much change was made to the right of way. Well, that's not what happened here. My client, who's a landscaper, cleared it, has made it better. He's built walls on his property, not part of this case. He's put in beautiful Christmas trees that actually have privacy. He's a landscape professional and he's improving his property. And he wants to make sure that his only access is this street and he can maximize it, and the law allows that. Also remember here.
But does he have a second way of entering and exiting his property as brother counsel suggested?
No, well, he does, but he's gonna have to take down a chain link fence. He's gonna have to fight with people who park on Route 127 to go get their ice cream or their subs across the street. So there's parking on the other side, and his property is fully fenced in on the other side. In the ancient—
Is it his fence? Is it his fence?
Part of it is because he's actually put a new fence in. So as you face Hale Street, there's now a new improved fence. So you don't see—
I'm just going to interrupt you for 1 second. So the short answer is yes, he has another way in. Let me ask you
another
this.
way out, but I bet you he's never used it.
He may not have used it before, but he may end up using it. We'll see. But let me ask you this. Your brother says that he's blocked off a portion of the way. Does he have a right to do that?
He didn't block off a portion of the way. I don't know what that's referring to. I have never heard that before, and it's not— oh my God, do I wish there were views in some of these cases, because that property, that way is wide open. And when the city of Beverly goes to their property, which is in the beginning of the way, it's beautiful, it's wide, it's never been changed. The same with the appellant. She's the first one that exits off the way to the right. That's never been changed. The trees cut are after that go directly to my property. And in the old days, used to go to 3 or 4 houses down the way, which now have their access off Hill Street. So my client is the only one that has to go the extra 150 feet or so to get to his property, and he needs this road. He is the one that's affected by it. He is—
your time has expired, so let me just check to see if there are any additional questions.
No, thank you.
No.
Seeing none, thank you all. The matter will be under advisement.
Thank you very much, Ron.
We are live and on the record.
Thank you. Our next case this morning is 2020 P0652 in the matter of LS. I will remind everybody that this case is impounded, so please use pseudonyms for the parties' names. We also have the same rules of court as though we were in the courtroom itself. So each side is permitted 15 minutes. There is no rebuttal. As I've discussed with the lawyers, the 3 appellees have decided how they're going to split their 15 minutes. We have read all of your materials, including the records. So the best use of your time would be to get right into it. So with that, we will hear from the appellant mother's lawyer, which is Attorney O'Brien, when you're ready.
Good morning, Your Honors. May it please the court. Attorney Gary O'Brien on behalf of the appellant mother in this case. As indicated in our brief, we're in the sort of unique position of appealing a case from the probate court where the trial judge dismissed a petition for custody with regard to one child of three children. So it's a little bit of a unique position in terms of that, in terms of why we're here. Our argument as set out in the brief really encompasses three distinct arguments, which are obviously intertwined the way they often are in these cases. The first argument is
a procedural question, Attorney O'Brien.
Excuse me, Judge.
I'd like to ask you a procedural question that Father's counsel brings up in her brief. And I've looked at the docket. It appears that your notice of appeal is for 18A0052, which was the sua sponte transfer to DCF and the resultant 72-hour hearing and that. The judge entered orders on the 14D0214, which is the Domrell docket, but there was no notice of appeal filed as to that. So I'm concerned that the only thing that's properly before us is the appeal of the sua sponte, which was ultimately a dismissal.
That's correct, Your Honor. That's all that's so in this situation, it's my understanding at the trial level, mother was pro se in the divorce proceeding, and then counsel was assigned in these separate three DCF sua sponte custody hearings, the 18A docket numbers. So we're appealing on behalf.
If mom agrees that the only thing before us is the dismissal, isn't it moot then? The sua sponte was dismissed, and then the case is proceeding in the Domrell docket.
Well, I think what our argument is on appeal is that it's not moot, that in fact that the court erred by dismissing the custody proceeding, the sua sponte custody, and that the court should have continued custody with the department of the one child at issue here. The other two siblings still one has aged out at this point, but the other two are still in custody because mother was not in a position.
She doesn't object to the dismissal as against her. She objects to the dismissal
against father.
As against father?
Correct.
And in a DCF, CMP, or sua sponte, does she have standing to object to that without an appeal of the underlying temporary custody order? Maybe standing is not the right word, but I'm trying to figure out.
Well, I think she has a vested interest in it, because one of the issue with regard to mother is that she didn't participate with regard to the hearing because she had moved to New York, and so pending was an ICPC interstate compact to decide whether or not the child could be placed with her in New York. So her standing is with regard to that. She is concerned for her child and feels.
But then any claims that she has as against dad and his parenting ability, she is not precluded from bringing those before the probate and family court judge in the underlying Domrell proceeding. I'm a little confused.
Well, I think she perhaps is. I'm not counsel on that case. I'm only was assigned counsel and appealing the dismissal of.
So if you had a magic wand and you could write the order in this case, what would it say? Dismissal vacated.
Well, I think for the reasons that we've set out in our brief, that the case should be remanded back to the court to allow for one thing, the court entered a sua sponte order granting custody to father of the youngest child at the culmination, at the end of these proceedings, which trial ended in May. The written order came out in September of 2019 after 3 months. But there was no opportunity for mother to address that issue.
That order didn't enter in the, I mean, with the dismissal, obviously the order entered in the domestic relations case.
That's correct, Your Honor.
Okay, so that's not part of this appeal, correct?
That's not, Your Honor. That's correct. I think, again, our position on appeal is, and I'm not involved, I don't represent mother with regard to the underlying divorce proceeding. But one of the arguments I think that other counsel make in their briefs is that this is really, the sua sponte custody order is really an extension of the underlying divorce proceeding. And I think that, number one, there's not really a citation for that. But secondly, the court treated these as entirely separate cases. They each had an independent docket number. Each were assigned counsel. Mother was assigned counsel. Each child was assigned an individual counsel. The court looked at and cited care and protection of Zeta, which we cite in our brief, basically looking at saying, I can take notice that I sat on a related case, that there are the docket entries, but I think, as we point out in our brief from page 26 to 31, examples of where the court had sat on this case for years. I mean, this has been an extremely litigated case for many years, and the court took credibility determinations and other evidence and commented on evidence that he had sat on previous that were outside the docket entries. And it wasn't just that, well, we've already been through a lot of this, because a lot of the evidence that was in the original case was presented and re-presented so that it fit within the guidelines of the hearing. The hearing has held over 8 days.
Wasn't it that evidence that spawned the hearing?
I think the concerns were, Your Honor, that that were raised, but they weren't evidentiary hearings per se. They were ongoing litigation in the probate court that led to the court sua sponte granting custody to the department, and then having the hearing over 8 days. So certainly, over the many years of the proceedings in the probate court, the court became aware and concerned enough to sua sponte grant custody to the department. What our argument is that once that set that down and set a separate proceeding, that that the court set up a guideline and a framework to say this is the evidence that comes in at this hearing is what we're going to consider. Trial courts do that all the time. They rule on evidence that motions in limine or hearsay, and they disregard and only rule on the evidence that's presented at the hearing. And so what our argument is, again, referring to our brief, is that the court considered evidence separate and apart from what came in at the hearing, and we submit that is error.
Was there, I'm sorry to interrupt you, Mr. O'Brien, but was there an objection to the court's consideration of that outside evidence that you can point us to, or was that waived?
I don't believe there was an objection. I think some of the evidence that we refer to in our brief is testimony or the court commenting on certain evidence at trial. I don't believe there was an objection in the record at that time, to be fair. I think the other parts of it were in the written decision itself, which commented on and made certain comments on mother's credibility and the evidence. And I think the other thing that's kind of intertwined with all of our argument is that to the extent that father found that the department hadn't proven by preponderance the evidence that father was not fit to care for the youngest child, each time the court's considering that, it's really weighing the issues of mother, reflecting on that mother is causing the allegations against father. So that it all became intertwined together with regard to that issue.
But doesn't the court point to the father's conduct throughout and his relationship with LS and the many things that the father did to suggest that he was indeed fit.
I think that's certainly part of it. I think that I think our argument isn't, certainly there's that evidence, to be fair, Your Honor. I think our argument is that in terms of the overall conclusion of fitness, that there were other parts of it that led to that the department had proven their case by preponderance of the evidence, especially I think looking at that the court was quite concerned with the sexual abuse and physical abuse allegations, but didn't look as much in terms of the mental health and the mental well-being of the child. And the other part of it that really failed to distinguish that, and the department argued at the trial court, was that the court couldn't find definitively that the father didn't abuse the older girls, but definitively found that he had not with regard to this child, and that there wasn't a distinction between the two of them. And that the department argued, which we would submit was the correct, is that if you can't find with regard to the older two girls, then you can't then make, where is the delineation with the younger child? So those are, I think one other point, just going through my notes to try to make sure that I address all the points with regard to what counsel had raised in their briefs, is that they point to at the beginning of the case where citing, I believe at T15, where the court said that they were going to consider the divorce case. And I think what the court said at the beginning was that if I don't find by preponderance of the evidence that either parent is unfit, then the petition would be dismissed, and I would then entertain arguments under the current modification. I think that's our argument, that if the court was going to deny the department's petition or find that they hadn't proven any of the petition, then there would be set up for a hearing or some sort of argument with regard to the modification. And yet the court just went ahead in the same decision and said sua sponte, I'm entering order in the divorce proceeding. So I think those are our arguments. Again, I think intertwined between all of it, as I believe the department and all counsel cite in their brief, Lori, for the proposition that these cases are really extensions of the underlying divorce proceeding. And our argument on appeal really is that they're not, they're separate proceedings, and that they're designed in the same sense as a 72-hour hearing in the juvenile court, and that the same standards, and in fact, what the court incorporated and set out here was to abide by Zeta and the proceedings and how Zeta guides to say, I can take judicial notice that I sat on this proceeding and the docket entries, but not to take into account the evidence and the judgments or decisions on credibility and other issues that we cited in our brief. I think if there's no other questions, we would rest on our brief unless there's any more questions from the panel.
I do not see any. Thank you very much, Attorney O'Brien.
Thank you.
Attorney Cuddle, are you going to argue first?
Yes, Your Honor.
Okay.
Your Honor, before I begin, can you please let me know when I'm getting close to my 8 minutes?
Absolutely.
Thank you. Good morning, Your Honors. William Cuddle for the Department of Children and Families. We're asking the court to affirm the trial court's decision dismissing the sua sponte order and transferring temporary custody to the father of the youngest child in this case. To begin, the trial judge conducted a proper 72-hour hearing under adoption of Lori. Just to remind the court, in this case, the 72-hour hearing went on for 8 days. There were 12 witnesses who testified. There were 39 exhibits entered by the department, 3 by the father. All parties were represented by counsel. It was a very thorough evidentiary hearing for the court to gather the information that he needed. And just to clarify, it can be tedious to try to follow along with all the different docket numbers in the case and in the divorce proceeding. I was not part of the case, obviously, when it was in the divorce proceeding, but clearly this is a very simple matter. As I about to say, the trial court under 119 section 23A3 has the authority and exercise the authority to take a pause in the divorce case because he had significant concerns about the potential for abuse or neglect of the children in this case. And it clearly was part of and continues to be part of the divorce case. This is not a Zeta case. As the court's aware of that case, there were two completely separate cases, different parties. This case is involving the same parents, the same children, the same judge. So mother's argument that the court incorrectly considered evidence from the divorce proceedings is unpersuasive. The court had an extraordinary amount of evidence apart from the entries of the divorce proceedings and the pleadings that was presented at trial to the experts to make the findings that he did. As you can see in the memorandum of law, the court heavily relied on the expert testimony of Dr. Childs, who was the reunification therapist for 2 years, who worked with the youngest child and father to really try to help them begin to establish a relationship. And the court relied on that testimony and found it credible from Dr. Childs that the child enjoyed his time with his father, that father was really working hard to establish a relationship with his son, to give his son the room that he needed to work through that relationship. And the court really considered that evidence. And it's in addition to the entries, the docket entries, which are numerous in this case. You can just take a look at the docket entries to try to, as I'm trying to explain to the court, and you can see that the mother in this case ignored court orders. There was a pattern of making allegations of sexual abuse by the father against the children at times when the court in the divorce proceeding issued temporary orders that the parents agreed to about sharing custody, having the father begin to spend time with his kids. Every time that occurred, mother would either file a complaint in the probate court or would go to a district court to file a restraining order or to gain custody. The court didn't need the mother's testimony, even though the court heard the mother's testimony, to make the determination that mother was unfit to care for the youngest child in this case.
Mr. Cuttle, this is Judge Blake. I just want to ask you, is it improper for Judge's decision to take judicial notice of the prior proceedings within the context of the sua sponte hearing?
No, I don't believe it is, Your Honor, because under Lori, it's part of the proceeding. So our first position is that it was proper to consider that evidence, that information, and coupled with the information and the evidence that the court gathered at the 72-hour hearing, it was appropriate for the court to make the decision that he made. Although we also argue in our briefs that the court didn't even need to take information or evidence from the earlier proceedings at the 72-hour hearing to make the determination that he did. If you take, as I said, if you really take a look at the memorandum of law that the court issued, the court clearly relied on evidence presented at the 72-hour hearing to find that father was not unfit to care for the child, and more importantly, expressly found that the father did not sexually abuse the child. Do you have any other questions on that point, Judge?
Let me just check, Attorney Cutter. Judge Hand, did you have a question?
It was the same one that you had. Thank you.
So you have about 1:55 left, Attorney Cuddle.
Okay, thank you, Your Honor. There was no error in this case. The trial judge made the sua sponte order, made the decision that there was insufficient evidence to find that the child was in imminent risk of abuse and neglect in father's care, and then really had no choice at that point. Once he made that determination, you know, the mother's asking basically for the court to ignore the evidence and to keep the child in the department's custody, which the court, after careful review of the evidence, was not going to do that. So the only option he really had, and this is why this is not a complicated matter, quite honestly, Your Honors, is that the court, under his authority, made a temporary order. I want to emphasize a temporary order to, under the divorce case. And I would be remiss if I wouldn't ask you to pay attention to the supplemental record appendix that the department filed with its brief. It provides the court with several of the court's decisions from basically June through October and November of 2019, when all these different matters were coming before the divorce case. And it clearly shows in the last order that the court made the determination that the sua sponte order should be dismissed, sent the case back to the probate court for further hearing. There was another hearing scheduled on, I believe it was October 3, a month after the initial hearing ended, where the matter of custody was going to be reconsidered.
Attorney Cuddle, this is Judge Blake again. You're down to about 6 seconds.
Right. I would also, with respect to father's argument about the mother waiving the issue of transfer of custody, I technically do agree with that. We didn't write that in our brief, but even if it's not the case, I think it was very clear that the court, there's plenty of evidence to show that the court properly transferred custody under 23A3.
Thank you very much, Mr. Cuddle. Attorney Williams, as we discussed, the clock will say 4 minutes, but you have agreed to 3.5. I will let you know when you're there.
Thank you, Your Honor. Good morning again. May it please the court, Attorney Heather Jo Williams for father. I have been involved with this family since 2015, I believe. I was there at the 8-day hearing. Although we keep talking about the lower court taking judicial notice of the divorce action, the reason that this 72-hour hearing took 8 days is because the lower court did not simply take judicial notice of the other action. We painstakingly put on witness after witness and exhibits and went through the history of the factual events to put the evidence before the court of those actions and events that occurred during the time period of the divorce, during the time period of the modification. And it simply was not just, well, I've already heard this in the other case, check the box and move on. The evidence was represented in this 72-hour hearing, and then that evidence was relied upon. At each juncture, while the evidence was being presented, although there were at times references to during the divorce hearing at such and such a docket, and then we went on, or the department went on to go through those documents and go through the witnesses that were in real time salient and important to those pieces. So it was not a matter, although the words judicial notice were used, the actual factual evidence was presented, and that is what is contained in the memorandum that Judge Decision eloquently wrote and supported when he dismissed the sua sponte order. I also note that counsel for mother argued that it was improper because the court found father unfit to care for the 2 other children, that therefore he's unfit to care for LS. The case law is very clear. RDVAH 454 Mass 706 2009. A parent can certainly be unfit to care for one child while perfectly fit to care for the other. I think the record is clear. This is a very unique circumstance and family as it relates to how the 2 older girls have been versus this little boy. And it was very clear how the judge distinguished why he found the father to be fit for LS and not fit for the other children. I really rely upon, when this appeal was filed, my first action was to reach out to appellate counsel. I said, you're appealing the wrong thing. What are you doing? And yet here we are with the same question. At the end of the day, the record supports a finding of dismissal of the sua sponte, and mother's grievance is really with the decision of the lower court under the divorce docket, which she did not file an interlocutory appeal. She did not file to reverse that decision, which she had every right to do so.
Are we reviewing for abuse of discretion or clear error or both or neither, where it's a dismissal?
I think that it's an abuse of discretion standard, Your Honor. Because it is dismissal. So the issue became, that was my first question. It's still a question today at the end of this. And I understand there was the argument made today that at the beginning of the hearing, the court indicated that if there was going to be a dismissal of the sua sponte, there would be a further proceeding under the divorce docket to determine which parent would then have custody. Because as a matter of law, once the sua sponte is dismissed, the custody would revert back to both parents, which was untenable. However, I think the judge in his discretion, after 8 days of hearing, did make an appropriate decision, did make findings to back it up, and did do a follow-up hearing where both parties were able to appear and present evidence had they disagreed with that decision. I recognize my time has expired.
Thank you. Attorney Kimball, the same thing. We'll put up the 4 minutes and I'll let you know when you're at 3.5.
Okay, thank you, Your Honor. May it please the court, I'm Deirdre Kimball and I represent the appellee child in this case. And I would thank both counsel because they have made excellent arguments in regards to most of the issues. In regards to my client, I would say that the most salient issue was mother's argument that once the court dismissed the sua sponte, and I'm not clear from either the oral argument or the brief what the next expectation mother had, but in my reading of it, my client was without a custodian. The court had found father to be fit and had found mother to be unfit. At that point, given the probate court must advance the best interest of the child, must look to the best interest of the child, had to find a custodian. On a temporary order, the court found, gave custody to father and scheduled a hearing for father and mother to argue as to who should have custody beyond that point, as the department was no longer the custodian. And
there was no interlocutory appeal of that temporary order.
Not that I have seen on any docket or been in receipt of. So,
did that hearing take place?
As far as I know, the hearing took place, but not being privy or an attorney on the divorce, I was not present, or did I investigate beyond the fact that my client still has a custodian?
Well, we do have the subsequent temporary order in the supplemental appendix that Mr. Cuddle filed.
And I believe that was the temporary order that was issued at simultaneous with the dismissal, okay. I believe. Were there any other questions in regards to that?
I don't see any.
Okay. And I would also state that this trial court took very careful consideration of the evidence and found that my client had not been abused in any way by the father. He and that was and to overturn that, as you had asked, would be asking the to look into the trial court's discretion. He was the one who saw all the witnesses, read all the evidence. Even in one point, mother's trial counsel, he asked a question about Dr. Bell, who was the psychologist who did an evaluation of both parents. Mother's trial counsel said, "Oh, you're talking about the divorce proceeding." In fact, the judge corrected trial counsel and said, "No, this was placed into evidence by DCF and is one of their documents. It's one of the paragraphs." The trial judge was very aware of Zeta and his obligations and acted accordingly. And I would ask that you uphold the dismissal.
Just check with the panel to see if there are any other questions. Seeing none, the matter will be taken under advisement. Council, thank you all.
Thank you.
We are live and on the record.
Thank you. The next case is 2019 P1547, James Fermin versus Daniel Rivera and another. Joining me this morning is Justice Desmond and Justice Hand. We are your panel for today's case. The proceedings will be as if we're in the courtroom, meaning that each side is permitted 15 minutes of argument. There is no rebuttal. And I believe, Attorney Jacobs, you are the appellant, so when you start, the clock will begin.
Thank you. May it please the court. May I begin, Your Honors?
Of course.
Thank you. Mr. Fermin is not contesting the statute that provides the municipality with the opportunity to dismiss a probationary employee at an extremely low level of cause. There doesn't need to be just cause. There is no right to a just cause hearing. They don't have to list details of specific incidents. He doesn't get to contest or rebut. Mr. Fermin is not challenging any of that. He is looking to the Costa case and the Duffy case, and he is saying that the statute itself, Mass General Laws, Chapter 31, Section 34, makes a requirement that the municipality, if it wishes to terminate a police officer who is probationary, and initially it was a 6-month probationary period, which the legislature extended to 12 months, giving the municipality an extremely longer length of time within which to evaluate the officer before that officer would come under civil service protection and have a property right, which would require a just cause for his termination and the right to due process notice and an evidentiary hearing. And what the legislature said was the municipal officer, the appointing officer, in this case, Rivera as the mayor of Lawrence, has to look into 4 categories: the conduct or capacity of the person. That means the conduct or capacity of Mr. Fermin, or the character or quality of Mr. Fermin's work. And then what the appointing authority has to do is he has to state in detail the particulars wherein, in one of those 4 categories, in his opinion, Mr. Fermin did not meet the satisfaction of the appointing officer. Now, Mr. Fermin, this is an extreme power that's given to the municipality. Mr. Fermin doesn't get to contest. He doesn't get to say, no, you're wrong. But I think the legislature intended that since it was giving so much power to the municipality, that the municipality had to at least state in detail the particulars, in the plural, why in one or more of those 4 categories, Mr. Fermin did not meet the standard. Now, my brother
Jacobs,
is...
could I ask you though,
Yes,
could
Your
I ask you, you make what I'm going to call a plain language argument, and you attached for us a host of dictionary definitions. That does not appear to have been your argument below. So why is that claim not waived?
It's not waived because my argument below, all along, throughout all the motions, is that there is a requirement for detail and particulars.
But did you argue plain language to Judge Feely?
I don't know that I specifically said plain language, but I said to Judge Feely in my motions and at the hearing that it was not sufficient to just use the wording of one of the 4 categories. The case law already says it's not sufficient to say not in the interest of the force or just general conduct unbecoming. There has to be detail and particulars. I made that argument very clearly. I may not have referenced dictionaries before Judge Feely, but I made the clear argument that if one looks at the Costa case, and we argued before Judge Feely that Costa and Duffy probably were relatively the controlling law. With respect to Mr. Costa, the termination letter said, quote, and I'm quoting from page 855 of the Costa case, quote, your inability to handle routine calls. That was one issue raised in the termination letter for Costa, and cooperate with and gain the cooperation of fellow officers. Those were three things that the appointing officer felt Costa had not met. That's
What is our
detailed.
standard of review?
Pardon me?
What is our standard of review?
De novo. This was a motion to dismiss. So you
All
look
right,
at
could
the
you
issue.
look with me then at page 12 of Judge Feely's decision? I'll read you the sentence I'm interested in. As to that claim, whether it's about plain language or not, as to the detail and particulars, Judge Feely writes, the letter directed FERMIN to the field training portion of his employment and directed him to his judgment and conduct during that portion of the employment, which this court concludes sufficiently references both his conduct and the quality of his work as being unsatisfactory. Why does that not meet the Costa-Duff standard?
It doesn't meet the standard of Costa or Duffy because in Costa, there was detail and particulars about his inability to return calls and cooperate with or receive cooperation from. The four areas that the appointing officer has to consider in deciding are conduct, capacity, character, and quality. You can't just refer, as Judge Feely indicates here, which is the appointing authority, Rivera's letter, you can't just say conduct. Conduct is one of the four areas.
He directs him to his field training, to his judgment, and his conduct during that field training. You would agree with me, there are no magic words. So why is this insufficient?
Because the four areas that must be considered are conduct, capacity of the person, character, quality of the work. Just using the word conduct, which is one of the four areas you need to give detail and particulars, is insufficient. There needs to be detail and particulars. There's nothing. If he said, for example, his judgment in deciding to arrest someone or his judgment in how he enters an apartment without a warrant, if he gave any kind of detail or particular, Mr. Rivera would be, I think, compliant with the law. He's not.
Let me ask you a different question. Let me ask you a different question. Assume for the sake of this question that we agree with you. Where does the statute provide for your client's reinstatement?
The statute itself says, in default of such notice, the notice being the notice describing in detail with particulars those one or more four areas, such person shall be deemed to be a tenured employee upon the termination of such period. Now, I would agree with Your Honor, because I think I'm anticipating where you're going, that this court might say that based on other sections of the statute, he would be returned to employment. However, just as with an educational break or an illness break, you would have to go back and complete the remainder of your tenured period. The court could very well rule, and I think that's within the nature of the statute, the wording of the statute, that Mr. FERMIN is reinstated to his position as a probationary officer, not a tenured officer. I argued in my brief that it should be tenured because the statute says in default of such notice, and I'm reading such notice to be a notice that's compliant with the statute. Now, Your Honor could say, no, we don't believe such notice means a compliant notice. We mean just any kind of notice. As long as the process of a notice was given, then he doesn't get returned to tenured status. He would just be returned to his probationary status. I think Your Honors could very well rule that, no, I don't get him back to tenured status. I get him back to probationary. And then in contrast to what my brother argues about hobbling the municipality, what Your Honors would be doing by returning FERMIN to probationary status is saying to the municipalities, look, you have a phenomenal power here to terminate someone's employment, just short stay of a year. He has no property right. He has no due process right. He has no evidentiary right. He has no ability to contest anything you're saying. You could be totally wrong about everything you're saying. He gets no right to contest it. That's a phenomenal power. However, you must give detail and particulars. If you return FERMIN, the city of Lawrence has 2.5 months under a new police chief, and as of today, I believe a new mayor, to decide, do they want to continue him as a probationary employee, or do they want to go ahead and ask the city attorney, who is exceedingly competent, or their outside counsel, either one, they're all competent counsel, to write up a letter and serve him by the end of the day, another notice that is compliant with the law. What I'm asking the court to
All right,
do is
Mr.
say,
Jacobs, let me just ask you, your amended complaint had 4 counts. Is it true that the only thing that you're appealing is the statutory violation? You didn't appeal the breach of contract or the implied covenant of good faith and fair dealing that Judge Howe dismissed on standing?
and I believe that is correct, Your Honor. I did not feel in good faith that I could go further after the court's decision on the breach of contract based on the collective bargaining agreement.
And do you, I know that you both have addressed this as a 12B or a Rule 12C motion, but is it fair to say that the judge conducted really a summary judgment of Rule 56 proceeding?
I think it is somewhat fair to say that he basically said that the FERMIN letter was referenced in sufficient detail that he felt, and I think he is correct, that he could take that into account. I think the only issues for the case. So
there's no issue of material fact. You both agree on what the letter says. It's just a question of law as to whether the words used by the municipality or the mayor meet the statutory definition as set out in Costa and in Duffy or Duff.
That's correct, Your Honor. And I think the issue, contrast to what my brother said in his brief on Duff versus School Committee of Milton, is there were 4 issues raised there. One was the quantity of work, which is related to work, but it's not listed as the category. The categories under the statute are conduct, capacity, character, or quality. And here they looked about the quantity of work, his attitude, and they looked at his cooperativeness. And then they made a specific reference in the termination letter in Duff to prior evaluations that have been sent to you. So the court there has felt that the letter, it was incorporated there. My brother says that the Rivera termination letter also incorporates material sent to FERMIN. That's not true. All the one has to do is read
that. Go ahead, Judge Desmond, I'm sorry.
Do you agree that the merits of the termination of his probationary employment are not before us? The issue before us is the draftsmanship of the letter itself, period.
I agree, Your Honor, that the merits of the arguments made by Rivera are not before the court. I would not agree that it's just a matter of draftsmanship. I think it's a more critical right of the employee who's on probation, who the legislature has given tremendous power to the municipality. They must, in keeping with that power that they're given, they must comply with the requirements of the statute and give detail and particulars. Otherwise, why wouldn't the legislature said, give a reason or terminate with no reason at all? The legislature didn't say you can terminate with no reason, or they didn't say give a reason. They specifically said and used the words in detail, the particulars. I don't believe the Rivera letter meets that requirement. But yes, Your Honor is correct. There is no dispute, I think. I don't want to speak for my brother, but I don't think we have any dispute. The termination letter was given. It was received by FERMIN within his probationary period. He was terminated on August 2nd. His probationary period wouldn't have ended until October 14th of 2017. So it was well within the period. If Your Honors believe that the letter does not meet the requirement, the city's in no disadvantage because
is it your position that the termination letter for the probationary officer would look exactly the same as the termination letter for someone who wasn't on a probationary officer?
No, I'm not sure. I don't understand your question.
Would the letter have to be as detailed had he not been a probationary officer is my question.
He would have had to have a due process hearing. The letter alone does not terminate a tenured officer. He has civil service due process rights to notice and a hearing. He has a property right in his employment with the municipality as a tenured officer. So the municipality doesn't get the right to terminate a tenured officer by a letter. The only one who can be terminated is a probationary. And my argument is this letter, if they put 3 or 4 more sentences, they would have been compliant with the law. They could have said, your uniform when you appear for duty is incomplete. We don't like the way you talk to the members of the public. Now, they don't have to say what member of the public on what day, but they have to give detail and particularity. Detail and particulars.
Attorney Jacobs, do you have any case where either the SJC or the appeals court found that the termination letter failed to comply with Chapter 31, Section 34?
We have not found any, nor has opposing counsel.
And
There
so does
were
that
lower.
suggest that it's a low bar?
It is a low bar, but it's a bar that in the FERMIN case was not met. I agree with you. The bar is one that you get no right to contest, no right to challenge, no right to a hearing. I correct myself. You get a right to.
You're not contesting the merits, though. You're just contesting the sufficiency of the letter.
That is correct, because that's what the law requires. The statute requires that the municipality be compliant in the manner in which they draft the letter. That we don't get a right, I don't believe, under probationary status to have a hearing and contest the detail, except that we do get that right, and we have that right. If the letter impugns his character or his integrity, then he has a right to.
But you're saying the letter wasn't enough, but you're not saying you're wrong about what you observed in field trading. You're wrong about my judgment. You're wrong about my conduct. You're just saying the letter isn't enough. I just want to make sure I understand your argument.
That is correct, because just referring to field training is referring to a point in time. It's not saying what is it in your field training that bothered the appointing officer with respect to conduct, capacity, character, or quality. You can give a point in time, but you need to give a detail in particular. Now,
his judgment, wasn't it his judgment?
There's no detail, there's no particulars. You need to say judgment with respect to how you speak to people, how fast you drive your cruiser. It has to be something more than the FERMIN letter. I don't feel it meets the bar.
Detailed in particularity. If I have to say judgment with respect to how you drive your car, that sounds detailed. And
but he didn't say judgment how you drive the car. He just said judgment and then repeated one of the words of the statute that is the area in which the appointing officer is supposed to concentrate. He concentrates his argument on conduct, capacity, character, or quality in one of those four areas, one or more. Does not have to be more than one. It can be one or more, but he has to give detail and particulars. He can't just use one word. He has to give something. And if you look at the Costa case, I agree with Costa. I agree with Duffy. Costa, your inability to handle routine calls and cooperate with and gain cooperation of fellow officers. That's all you need. That's how low the bar is. But I'm arguing.
Let me check. You're over your time. Let me check with the panel to see if there are any other questions.
Thank you, Your Honor.
Okay, thank you. Right, Attorney Fuedo, I'm not sure how to pronounce your last name. I apologize. If you could take yourself off mute, there you go.
Fuedo, Your Honor.
Fuedo, I apologize.
No problem.
When you're ready.
Thank you, Your Honor. We have here, for my brother in the court, wants to make a statutory argument. He has a belief as to what the statute requires, and he's making a statutory interpretation argument. The problem for the appellant in this case is the SJC and this court have already interpreted the statute in a manner that's inconsistent with the argument they're making in this case. So I would agree with you that the plain language argument that's being made here was waived below. You have been given by the appellant a list of definitions from a dictionary as to what this statute should mean. Below, the briefs had one reference to the dictionary, and it was as to in a footnote as reference to the meaning of probation under the statute. And specifically in the hearing, my brother disavowed the argument that he was making a statutory interpretation argument and made clear that Costa is the standard. The standard that needs to apply here is Costa. The Costa and the subsequent cases of this court have interpreted the language in the statute. And what do those cases say? Well, Costa says the standard in the statute that you have to say in detail with the particulars of conduct or capacity or the character and quality of the work, it does not mean you have to identify specific incidents or events. And it just has to be something more than a formulaic recitation of conduct unbecoming an officer or for the good of the service.
In retrospect, though, right? A couple more words, and I don't think we'd be sitting here. So
You're absolutely right. You're absolutely right. If this was a more verbose or detailed letter, there would have been no question. But the question is not, could the letter have been written better? It's, does the letter meet the statutory bar that the statute sets as interpreted by the SJC and this court? And as the Superior Court found, and we agree in this case.
But let me ask you, what did not demonstrate judgment required of a police officer and conduct during field training unsatisfactory? What does that mean?
Well, I think it's clear that they were from the language in field training, where there is some level of training, where these probationary officers learn to become police officers. At a certain point, the appointing officer came to have a subjective belief that this employee did not have this probationary officer did not have the judgment to become a tenured police officer.
But what does that mean? But what does that mean? If I'm FERMIN, how do I walk away saying they questioned my judgment because I drove my wife's car instead of my own personal car to the training, to the field training? Is it the judgment because I stayed around after the field training was? I mean, what does that mean? If I'm the employee, what do I look to say, gosh, next time I won't do that?
Right. And that where we would have had the benefit had there been more details in the letter, absolutely. But the issue is the statute and COSTA don't require those details. And so at that point, what that means is essentially, other than the plain language of what it means, there are no additional details that need to be provided for this letter to be sufficient under the eyes of the statute. It means what it says, which is during field training, we don't have to, that there were questions about his judgment and conduct. And the statute and COSTA is clear that you don't have to recite the specific incidences. Now, there likely were specific incidences, and if this case had gone beyond the motion for judgment, the pleadings that was filed by the appellant in this case, and then we cross-moved and the court ruled on that, we would have done discovery to figure out what the officer was talking about, what the appointing officer authority was talking about in that situation with reference to that letter. But in this case, before you, the merits of what that means are irrelevant. It's purely about whether this language is sufficient to meet the very minimal bar set by COSTA. And the Superior Court found that it is, and I think the Superior Court was correct on that issue. Now, the other thing the reason why there is this low bar was perfectly stated by this court in the Lemonster case, which is, in the context of probationary employees, decisions can be based on, and I quote, subjective judgment of an experienced person of what is satisfactory performance, akin to prognosticating future performance. So the reason why—
on that? I'm trying to find that.
That appears at page 127 in the Lemonster decision. And the appeals court this court has said that a letter that cites unspecified insufficiencies in quality and quantity of work performance and attitudinal problems, equivalent to you have a bad attitude, it's equivalent to you have bad judgment, is sufficiently detailed. So under these standards, I think it's clear. Mr. FERMIN would like the statute to mean something something different than what the Superior Court and the SJC and this court have interpreted it to mean, but it's just simply not the case. The Superior Court, the Supreme Judicial Court, and this court has had the opportunity, and Your Honor pointed out to consider these letters, and Your Honor pointed out a very, very important point that I want to reiterate, which is there is no decision of the SJC or the appeals court finding that a letter was insufficient under the COSTA standard. We had one case where the lower court found it was insufficient, and the appeals court reversed on appeal. But I think it's important to also to understand is even if the letter were found to be insufficient under COSTA, the statute There's no authority that says that that Mr. FERMIN then gets reappointed as a probationary police officer. He doesn't get reinstated. The statute.
What would the remedy be?
I think that there is no remedy. I think that you could order the court to provide you could order the appointing officer, I guess, to provide a more comprehensive letter, which we could. But the fact that the letter was insufficient doesn't negate the fact that he was terminated. And the relevant there's no case specifically on point on this, but I would point you to the Thibodeau v. New Bedford case, where there was, like in this case, if, assuming for the purposes that you did find that there was a procedural problem with the letter, that where the requirement to the copy be sent to the administrator of civil service was not met, and that procedural requirement was not met, the SJC said that doesn't mean that the person gets reinstated as a probationary employee. And that's because—
different question I have is, do you agree that this is a de novo review?
I do agree that it's a de novo review. But the SJC was clear that in interpreting the statute, and courts are not to read the statute to hobble the employer in the process of selecting employees qualified for tenure. It sets out a termination procedure, but it's not designed to make it harder for employers to terminate the employees that they consider to be unqualified. Now, had the probationary period passed and that person become a tenured employee, then as the statutory framework lays out, there is a process. There has to be just cause. That's not the case here. And so to interpret the statute to impose a remedy of reinstatement cuts against I think the purposes of the statute, but also the intent of the statute, which is the tenure system is designed to benefit the public. And the public isn't benefited if a public employee who is a probationary employee who is deemed to be unqualified is reappointed because the court determines that procedurally the letter was lacking in terms of detail.
So
it's very clear that he was terminated.
Is there any legal significance to the fact that FERMIN is not contesting the merits, but rather the sufficiency of the letter?
I don't think there is, because that would have been a separate procedure. I don't think that was an issue in this case. If he was contesting the merits of it, there could be a whole process in which he could. There was there was an underlying case before the labor board, I believe. So there are other avenues to pursue this. What's before this court is purely the question of whether the letter meets the standards under the statute. And I point out that a couple of the default of notice. If there no notice is given, that's a default of notice because the person is never terminated. So in that case, the probationary period has ended and that person has become a tenured employee, a tenured police officer. That's not what happened here. There wasn't a default of notice. A notice was given. The question in this case is whether that notice was appropriately detailed or not enough. But it's very clear that this employee was terminated during the probationary period. So at no point would he be entitled under the statute to be, as a remedy in this case, be reinstated as a police officer. That would exceed the remedies that are authorized by the statute. The other thing I wanted to point out is even assuming that the plain language argument was not waived on below, which we contend pretty clearly that it was. Even if it wasn't, these statutory definitions that Mr. FERMIN has put forward in this case it's just simply not how the SJC has defined in detail for the purposes of the statute. The SJC said that in detail did not include a requirement of describing incidents or events, and it consists of mere general impressions. That's language, that's what Costa says. So the other point here is that the appeals court said that in detail can be, quote, lamentably bureaucratic or even opaque. And you may argue that the language in this letter is simply that, but it still meets the standards under the statute. My brother also makes an argument with respect to the language of particulars in the plural, suggests that there has to be multiple specific items that are addressed in the letter. That's just simply not the case. Costa is very clear that says particulars means one or more problems with conduct, capacity, judgment, etc. So the notion that one issue, even though I would say two issues were raised in this letter, conduct and judgment, the fact that even if it was just judgment, that's enough. It doesn't have to be these multiple things. Even though it says particulars, Attorney Jacobs may think that the SJC erred in how they interpreted the statute, but that's the law of the land. This is what it is, and Mr. FERMIN can't substitute his judgment as to his reading of the statute for the SJCs. That's just not how it works. I think the last point, I actually think I've made all of the points that I want to make. Everything else can be addressed in my brief, so I guess I'll reserve the rest of my time.
Is there any other questions from the panel?
No, thank you.
Wonderful. We will take the matter under advisement. Counsel, thank you both.
Thank you, Your Honor.
And can we just caution, if anybody has another device on, that they turn that down? That might be what that feedback is.
We are live and on the record.
Thank you. Our last case of the day is 2020 P0019, VILLAR versus VILLAR. In this case, we had a meeting with the parties and the lawyer and the interpreter before we went on the record to discuss how we're going to use the interpreter. Mr. VILLAR is going to present the best he can in English, but if he feels he needs the assistance of the interpreter, he will let us know that, and Madam Interpreter, you will then become involved. After Mr. VILLAR speaks, Mr. LaRochelle will speak, and if at any time Mr. VILLAR doesn't understand something Mr. LaRochelle is saying, he will let us know, and we will again ask the interpreter for her assistance. Each side is permitted 15 minutes. The clock will appear in the top left corner where the court seal is. The clock will turn red when your time is up. And I failed to introduce the panel. I do apologize. My name is Amy Blake. I am pleased to be sitting today with Justice Desmond and Justice Hand. We are your panel for this case. So, Mr. VILLAR, as soon as you begin speaking, the clock will start. So the floor is yours, sir.
I can go ahead now.
Yes, sir.
Just to have a background, I was the breadwinner for 18 years in the Philippines, and then I became the role became the other way around when we settled down here in the U.S. And just to make also clear that the lower court never mentioned that I have been a homemaker. He never mentioned my my role as a homemaker, but mentioned more on the accomplishment of my ex-wife. Now the thing is, I've been supporting my wife for the entire for my life, and then so I was supporting them with all the comforts in life in the Philippines, but my fate turned the other way around, and she became the breadwinner here. While she was a breadwinner, she asked me to drive for her, to drive for the kids, for, of course, to act as a housebound. And I did that, and it was never mentioned, and she even denied that that I was a homemaker. And apparently the lower court was very silent about that. And he was so silent, the court was so silent about my accomplishment that up to the extent that the court decided that I have no alimony. And they also showed that I have plenty of money because of my family, because of my inheritance. That's not the case. and they blinded they colluded. I will say they colluded. The lawyers colluded about my income and about her income too. That my ex was only having an income of 85,900, but 800, but it was not. They by penalties of perjury, the lower court must be this one, the attorney La Rochelle, must be punished for perjury because he consented to get the pull the figure to the higher court to the court. Then it was based as the decision.
And Mr. Villar, with
Yes.
respect to the earnings of $85,000 a year, you rely on some documents, some 2019 documents, to suggest that she was making, I think you said 135,000 or some higher figure. But those documents weren't before the court in your trial, right?
Yeah, I mean, I'm sorry, I didn't get what you said. I'm sorry.
The documents that you rely on to suggest that she made more than $85,000 a year, those 2019 documents didn't come into your possession until after the hearing.
Yeah, this is what I understand from your question, that if I have proof in the higher income of my ex, I have. In fact,
Hold on. I'm going to ask the interpreter to interpret my question, if you don't mind.
Oh, yes, thank you.
So, Madam Interpreter? Is the interpreter there?
Madam Interpreter?
I am here.
Okay, Justice
Hello.
Desmond has a question for you to interpret.
Okay, I'm ready.
Would you ask Mr. Villar if the documents that he relies on to suggest that his ex-wife made more than $85,000 a year, were they submitted to the court during the hearing?
Ginong Villar, yung mga dokumentong isinumite mo ay yung ba ay nagpapatunay na ang kinikita ni Mrs. Villar ng 85,000 ay mas malaki?
Mas malaki po ang kinikita ng aking dating asawa kaysa dinideklara niya. 2016, ang income niya ay 100,000. 2017, 133,000. 2018,
Sandali. Ginong Villar, isa lang po. Dahan-dahan lang. Hindi. Ginoong Villar, sandali lang po para masabi ko sa Ginoong Hukom ang sinabi mo. The document that we submitted was the income of my wife is higher than my income.
Okay, thank you.
Mr. Villar, you should continue.
Tuloy ka, Ginoong Villar.
2017 po, maklarado ko lang, ang income niya ay 133,000 and
Hold on
10
one
cents.
moment. It looks like we may have lost.
2018.
Hold on. We may have lost the interpreter. So just hold on one moment. Ms. Ryle hopefully is trying to get her back. I will note that we were at about 9:20 when that happened, so we will make sure that you get all of your time. Don't worry about that. Ms. Ryle, are you there? Are you able to hear me?
Yes, Your Honors, I'm here and I'm trying to contact the
Thank you so much. Is there a way to stop the clock?
There is not, but I can restart it around 9 minutes.
Okay, perfect. Now we know the static was coming from her phone because it's gone. With the Zoom platform, but we're back and we're going to set the clock at 9 minutes. Mr. Villar, when you start to speak, the clock will start again. So I'm sorry for the interruption, but please continue.
Yes. Just to repeat what I've said, I'd like to tell the court that my ex, contrary to her 85,800, in 2016 she made 100,000. In 2017 she made 133,000.10. In 2018 she made 128,000 something, or 133,000, and it is not 85,800. And they are just made up by this, I don't know what kind of lawyer is this. The liabilities also, because I don't have a job. Right now I don't have a job. I'm on SSI, SNAP, or the food stamps. I have no means of really fending to myself, and when I was only earning 14,000 in 2017, they gave me all the liabilities. They let me shoulder all the liabilities, including the liability of everything, including the Nelnet, and then the credit card loans. They gave everything to me without any consideration of the real computation of the alimony computation or the equitable distribution of wealth, of liabilities and wealth. They did really not follow the rules, and because of that I got jailed 3 times, and I'm sick because of that. I need justice. I need justice for all this deceit that they made. I'm really sick, and I have no job at all right now because I'm sick. I cannot go to work. I was working, and yet these guys are bothering me, and I cannot even pass the exam because of this. And I got sick, and they destroyed my life with all their deceit. And I think in some ways, there's a collusion in the court. Yeah. They are, I can literally say that this lawyer is corrupt. The one that I'm looking at that lawyer, he is a corrupt, cruel, and really a liar. You sent me to jail. An innocent man. You sent me to jail.
Try to address us, Mr. Villar, not the attorney. Please direct your comments to the panel.
Yes, I'm so emotional.
That's okay.
Judge, I don't deserve this. I don't deserve this punishment. They just made up their own story, and then here come. They keep on banking on their theory that he was only making 85,000, that I have more money, I have inheritance. I already used my inheritance for my lawyer. I gave around 8,000 to my son, and yet they're looking for that. Before the trial went on, they asked me, my lawyer, who is, I think she is in connivance also with the other lawyer, she's asking for the 21,000. Where did that money go? I said, I already spent it. I don't have money anymore. And they are banking on that. My family has plenty of money. And Attorney Rochelle said, and the other guy said that I'm hiding money. I'm hiding money for what? The opposition party will say that I'm hiding money, and the court will follow. Yes, he's hiding money. Because he's hiding money, you'll be imprisoned. You'll be jailed. But this has no basis at all. Their findings have no basis at all, and there's not even a forensic accounting. My sisters were not even called to testify, and yet.
Mr. Villar, are you still living in the home?
No more. The house was sold, and I was never a participant. Okay. And yet they're letting me pay. I did not receive any money, and yet this liar. Oh, I'm sorry. The other party said that I was given 17,000. No, No, and if you wish, I can please consider my addendum, because that includes everything that happened, how they went about it.
When was the house sold? What year?
Just this year.
2020 or?
September 4.
Okay, thank you.
I was kicked out of the house. I was imprisoned just because of that, so they can go sell the house. I was inside the house, and they called me, and then I was imprisoned. Then they went along with the selling of the house.
Do you know what happened to the proceeds of the sale?
I don't know. I don't know. They just need the money. They just got the money. I have no money. I deserve an alimony. I've been so loyal to my marriage. And the licenses, I was a participant. I financed her education, nursing education. I dental education too. I assisted her. And yet this guy, the other party, won't say that it has no value at all. It has a value. I'm not a lawyer, but
Mr. Villar, I just wanted to help you understand that a little bit. In some states, a doctor's license, a lawyer's license, a nurse's license has a value separate from somebody's income. But in Massachusetts, our highest court has not yet ruled that way. So it's really what your ex-wife makes for a living that's the issue. The license is not considered in Massachusetts. It's just the way the law is in this state at this point in time. I just wanted to tell you that so I could help you understand it.
I got you, Judge. Okay. And then, but I need also to point out that I'm instrumental in getting her license. Without me, without my family, my sisters, she can never get the license. Without me, without my sisters, she can never make a down payment for the house. She can never make a down payment for the car. She will not be in her position right now without me and my family. And yet she is discounting everything that I was not a homemaker. And the court was silent about that.
How long were you the homemaker, sir?
More than 10 years, Judge. More than 10 years. And it was never emphasized in the narrative of the court. That's why I'm submitting my addendum, so it will be a revelation that what happened and what collusion happened between the two lawyers who are, I think, corrupt. Thank you very much.
We still have about a minute and a half if there's anything else you'd like to tell us.
Please. I just need, if you need more information, because I have a tape, I have a worksheet for the proving that my ex can afford to pay the alimony. With just $133,000, it is already strengthened that she can pay alimony. But if you want to have a real detail that she can comfortably pay alimony, pay the mortgage, pay everything, I am trying to send you the worksheet in USB and also my addendum. That's only my request. If you want to see everything that really happened with the corruption of this. Thank you very much. Thank you,
anything
judges.
Else you'd like to say, sir, or have you completed your presentation?
I have completed my. I'm sorry, I'm too emotional because I'm sick.
No, that's okay. You're not too emotional. Don't worry about that. I just want to make sure that you have said everything that you wanted to say to us here today. Yes. Okay, now it will be Mr. La Rochelle's turn to present, and unless you need the interpreter, you cannot address us or Mr. La Rochelle. So if you need the interpreter, raise your hand, okay?
Yes.
Okay. Attorney La Rochelle.
Thank you, Justice Bike, and may it please the court, I don't intend to defend myself against allegations of being corrupt and having committed perjury and having colluded with my adverse counsel and with the court to pervert justice, but I will try to talk to the issues that I understand Mr. Villar has. It's sometimes hard to follow his logic, but I believe he's addressed a few issues in his brief, only a couple of which have been talked about at oral argument. So I trust the court will direct me toward or away from whatever issues it is the court wants to hear or not hear. I think the primary issue that Mr. Villar has from a substantive standpoint is the fact that the trial court did not grant him alimony. And the trial court did not do that because Judge Simons found that the primary reason was that Judge Simons found that the wife did not have the ability to pay. He did that based on her financial statement and her testimony that she was on a weekly basis $879 in deficit. There was no evidence introduced that indicated that was not correct. In addition, Mr. Villar, at the time of trial, was also in a deficit situation, but much less than his wife was. His deficit, according to his financial statement at the time of trial, was $326 per week. Now, of that $326 a week, Mr. Villar conceded on testimony at trial that $107 of that he attributed to entertainment and dining, he would only spend if he was actually awarded alimony. So that is not an expense he actually had. Additionally, $138 per week that he claimed on his financial statement that is part of that deficit that he alleges was voluntary payments to his adult son. So both of those should not be considered part of his financial situation as far as whether he is entitled to alimony or not. And if you take those out, plus his testimony that he could easily cut his additional expenses some, essentially entirely wipes out any claim he might have to need alimony. So the judge was correct on those numbers and on the facts presented to him that alimony was not warranted in this case. There's no error there. What Mr. Villar spends a lot of time concerned about is he believes that the wife's income at the time of trial was misstated and misstated in a low direction. And he's mentioned that, and Justice Desmond asked him about where he got that information from. And I can help clarify that a little bit. It is true that Mrs. Villar earned more money in 2016 and 2017 than she earned at the time of trial. She testified about that. She testified how her employer, not through her fault, but through a reduction in hours, reduced her hours from what was originally 64 hours per week she was working, down to 36, and down to 30 prior to trial. So at the time of trial, she was working 30 hours a week, $55 per hour, which is $1,650 per week, and $85,800 per year, which is exactly what her financial statement says, exactly what she testified to. The other thing that Mr. Villar is doing in this appeal, I think improperly, is he's taking financial statements that the wife filled out a year and a half and 2.5 years after trial and saying, look, after the trial was over, she made more money too. As Justice Desmond has already suggested, it's not proper for him to do that. That evidence was not available at the time of trial. It's not relevant to what she was making at the time of trial. Certainly not proper to be brought here. I would mention that Mr. Villar has never filed a motion to reconsider, a motion for relief from the judgment, never filed a complaint for modification, or even filed a motion to stay the prior judgment. The second thing that Mr. Villar is upset about, which he mentioned a little bit here today, but certainly in his brief, is that he thinks the distribution of assets and debts that Judge Simons awarded is improper. But if you look at the actual numbers of what Judge Simons awarded, and I've set them out on page 18 of my brief, if you want to take a look at the detailed calculations, but Mr. Villar actually got almost $17,000 in excess, assets over debts. He got $17,000 more in assets than he took of the marital debt. On the other hand, the wife took about $27,000 more in debt than she did of the marital assets. And
Attorney
this is
Costa,
after.
could I ask a
I'm sorry.
question about that allocation that you have on page 18? One of the things that you list for Mr. Villar includes his real property holdings at $27,500, which I think it takes into account a $21,000 piece of property in the Philippines. Is that correct?
That's correct, Your Honor.
Wasn't there agreement
Those were on his
before
financial-
trial? Wasn't there agreement before trial that that property had been disposed of previously and then the money returned and reborrowed at some later time, but that property had been addressed? I was looking at the pretrial conference hearing reported or transcript, and my recollection is that there was some information about that. Am I mistaken?
Not that I recall, Your Honor. There certainly was no agreement. Mr. Villar may have said that, but there was no agreement. I don't think there's any testimony to that effect in the trial transcript either.
Okay, thank you.
All right, Your Honor, thank you. In addition to what is essentially a $45,000 benefit to Mr. Villar over Ms. Villar in the distribution of assets, Mr. Villar also was allowed to remain in the marital home and only pay for half of the expenses of doing so. The judgment required that he pay half of the mortgage, half of the taxes, and half of the insurance on the house, and be allowed to continue to remain there. In fact, he didn't pay any of those things, but he still remained there for actually over 2 full years after trial. And so that's another benefit that he got on this distribution. He also had the marital home sold for more than the parties' joint debt, because the proceeds of the sale of the marital home were directed by judgment to be used to pay for the joint marital debt, which, by the way, Justice Desmond, answer to your question, the proceeds from the sale of the home was not enough to cover all of the marital debt, but the amount of the proceeds was all given to reducing that joint debt. But what I was talking about with the judgment says that if there was an excess, if in fact the house sold for more than the marital debt, that Mr. Villar would get all of the excess. So I really don't understand Mr. Villar's argument that he was treated unfairly in the distribution of assets and debts, because he actually fared much better than his wife did after this long-term marriage in which all the assets that either of them had were certainly meritable and divisible. Those, I believe, are a fair assessment of the substantive arguments that Mr. Villar makes. He makes several procedural arguments, which are perhaps easily discussed, and I'll start them unless the court tells me to stop. His first one is that he feels the trial was rushed and he was not allowed to bring the witnesses that he wanted to bring. But if you look at the record, and I pointed to the specific parts of my brief, in fact, Mr. Villar originally, with his first counsel, planned to go to trial with only himself as a witness. When he got his new counsel asked the court to expand his witness list so that it would be 4 witnesses instead of 1. And the court agreed to that. On the day of trial, Mr. Villar showed up to trial with only himself as a witness. He can't blame that on the court. He certainly can't blame that on Ms. Villar. That was his choice. He also says that he didn't have time to present his case. And yet, at the beginning of the trial, before the testimony started, I, as the wife's counsel, suggested to the court that the parties should not be limited in the amount of time they had to testify, and the court agreed. So in fact, Mr. Villar had as much time to testify as he wanted to. If you look at the trial transcript, the testimony, particularly at the end of the direct examination and the end of redirect, there's no mention from the court. There's no indication that the court is in any way rushing his testimony or preventing him from completing his testimony. His counsel just basically ran out of questions. Another thing that he brings up repeatedly, and I guess this is part of his collusion argument, is that he says that he's had ineffective assistance of counsel. Well, as your honors know, he's not entitled to assistance of counsel at all in a divorce. Certainly has no right to an effective assistance of counsel, and that is not a ground for bringing an appeal. He may have an action against his attorney if he wants to bring it, but it's certainly not a ground for appeal. He also argues that a language barrier was a problem of his at trial. And yet the first time that he ever brought up language as a problem, the first time he ever asked for an interpreter was on May 23rd, 2019, which was almost 11 months after trial. So he can't be heard now to complain that, you know, that he should have been an interpreter at trial, when in fact, he never asked for one. And there was absolutely no reason for the trial court to believe he needed one. Mr. Villar testified at trial that he'd been speaking English since he was a toddler, been living in the United States for almost 17 years at the time of trial. And in fact, if you go back and read snippets of his trial testimony, and I've pointed the court to at least one of them, he uses very complex words in proper context with proper meaning. So there's certainly no reason for the trial court to sua sponte decide, oh my gosh, this gentleman needs an interpreter. And in fact, it's not an appealable issue. Finally, he talks about the dental and the nursing issues, and I appreciate Justice Blake, you've already given him some help on that matter, but this was a matter that was never brought up at trial, as Your Honor suggests, because it wasn't appropriate to bring up at trial. And certainly he's not allowed in any case to bring up an issue for the first time on appeal that was not brought at trial. There are some post-trial things that Mr. Villar is concerned about, and I want to address them if the court wants to hear it. He first talks about the fact that the trial court awarded my client $16,272 of her attorney's fees to be paid by him. And the reason after trial, it was found that a party did not accept a settlement offer that was better for that party than what was ended up being the judgment, that he would entertain a request for attorney's fees. And in fact, that's what happened. If you look at the settlement offer that I provided to him in April of 2018, which is at page 201, volume 1 of the appendix, it essentially tracks almost exactly what the judgment was, with one notable exception, and that was that we offered to give Mr. Villar $162 a week in alimony. He rejected that offer, wanted to take his chances at trial, ended up with a worse judgment, and Judge Simon said, as I warned you, if you don't take a good offer, I'm going to saddle you with the waste of attorney's fees that you saddled your spouse with. And the judge found that to be $16,272. And Judge Simon's ordered that he make those payments at a rate of $678 per month, which I will note, by the way, he's not made a single payment of. 3 times, Mr. Villar has been found in contempt by the lower court, and I'll go through them quickly. He has never made any payment toward the mortgage, toward the insurance, or toward the attorney's fees. And twice he's been put in jail for that. The first time he was put in.
Those judgments are before us, Mr. La Rochelle, right?
It's really not, but he addressed it, so I will not address it if you don't want to hear about it.
Well, we can only address what's on appeal.
Very good. Then I have really nothing else to offer other than I feel for Mr. Villar. I understand he feels he's been wronged, but under the law, Judge Simon's judgment was exactly correct based on the evidence that was before him. And Mr. Villar, unfortunately for him, really has no grounds for appeal. Thank you, Your Honor.
Thank you all. The matter is under advisement. Madam Interpreter, thank you very much. You are released.
Yes.
Thank you to both parties.
You're welcome. Yeah, thank you.